Hello and welcome to the regular meeting of the Pitkin County Board of Commissioners on Wednesday, November 15th. We have Kelly, Greg, Patty, and myself, Francie, in attendance here, and I'm expecting Steve to jump in shortly online.
You can take that if you want.
John, do we have any additions and deletions to the agenda?
There are no additions or deletions to the agenda today.
All right. So then I will open public comments. These are comments about items that are not on the agenda. Is there anybody in the public who would like to comment? Ellen, come on up.
Remind me again, red light on or off?
Red light on.
Okay. Ellen Anderson, concerned citizen, Aspen Village residents. I just have a question. For agenda item number 4, will you be taking public comment for that agenda item, the emergency ordinance?
Item number 4, the Pitkin County Board of Appeals.
No. Oh, I'm sorry. The emergency ordinance amending the Pitkin County Code. It has to do with the airport.
It's a emergency ordinance, so confirmatory readings on the 6th.
You're wondering if I would take public comment on
Yes.
that today?
Yes. Which it's.
I will when it comes up.
Okay,
yes.
thank you very much. Bye-bye.
Okay, Commissioner comments?
Sure.
Greg?
I have one. I think I caused some consternation in the community recently regarding a comment I made about TDRs, which I find to be factually incorrect, and that was that fractions of TDRs that are left over from a property owner can be used for future development on that property. And I did not, I didn't say that. I said it improperly, and I was mistaken. So Suzanne Wolf has corrected me, and basically the true comment would be remaining square footage can be used only on the property where the TDR was extinguished. And our advisory committee has not made any recommendations on that issue. I just wanted to bring that up because I know there were a few people, we got a couple letters, and I apologize to them, and I stand corrected. Thank you.
Thank you, Greg. Anybody else? Well, I have, Steve, go ahead. Hi, welcome.
I tried to come today. I ran afoul of a bus that was not running on schedule apparently. But I stood out there for 20 minutes about, and then I realized I was not feeling so hot and my cold is still bad, so I just came home. I apologize for not being there. I really tried to come, but I will be here on Zoom call. Thank you.
Yeah, well, thanks for joining us, Steve.
Feel better, Steve.
An update for the public on the immigrants from Venezuela. I have spoken with Irene at Voces Unidas, and she is taking in the names of volunteers who would be interested in fixing dinners for them. She can be reached at irene@vocesunidas.org. That's VOCESUNIDAS. Irene at vocesunidas.org. She is covered through Friday for dinners for them.
How many people, Francie?
They're about 60. You should count on about 60. There's really about 30, but some of them come in late when they finish their jobs for the day or whatever they've been doing. So, RAFTA has donated 100 bus passes worth about 40 rides each, so that these people can get around the valley looking for jobs without jeopardizing the cars that they have, which are not all well signed up with our state. And so if you're interested in cooking food, call Irene. The people are incredibly appreciative. There are no resources on site. So you need to bring your own, hopefully compostable plates or bowls. I take real silverware when I go and just put it in my dishwasher when I get home because it's not pleasant to eat off of plastic. There are compostable utensils available, though, at stores. So there's no cleanup at all there available. So what you bring, you take home with you and clean it at home. It's a very well-organized situation. You'd be very welcomed if you go there, and people will appreciate you. And anything else from anybody? Yes, Kelly.
Just wish the community a happy Thanksgiving. I hope there is hope in all of your lives and hearts. I know it can be very hard with things going on in households and families and communities and in the world. But I will be sending all my love and light out to all of you.
Thank you, Kelly. Okay.
One
Yeah,
more thing,
Steve.
Francie.
Go ahead, Steve.
The senior center is now officially open again. The meals there will be at the senior center. The new chef won't start preparing meals until December, the first week in December. So it still is the catered meals will be provided. But you can go by the senior center and see the remodel of the office space and all the new furniture and tables and chairs and whatnot that they've gotten. Thank you.
Thanks, Steve. Okay, we'll move on to consent items. The first one is a resolution to appoint citizen board members and amending resolution 020-2023. I don't see Charlotte.
I will move to approve with a comment.
Go ahead.
I just want to thank, again, as we do with our appointed boards, thank people for their time and their energy that they put forward. And so I want to thank the members of the appeals board.
So should we mention who we're actually appointing here?
I can read the names. William Stryker, William.
No, that's not that. It's Mache.
Oh, I thought, sorry, I have this one in front of me. I meant Mache, what's Mache's?
I can't remember Mache's last name. It's Mache
Rotec.
for the Healthy Rivers and Streams. And
So I want to thank her, and I'll thank the other ones when we get to them.
Mache is a man.
Moving it forward for you, right?
And he's being appointed to Healthy Rivers and Streams. And the other person is Lisa Baker for,
Financial Advisory Board.
thank you, Financial
And that was
Advisory
the one
Board.
we missed from the
Yeah,
last.
and
approval.
so, and that term will expire April 1st, 2027, and Mache Rotec will be with Healthy Rivers and Streams until September of 2027.
Mache, that's a great name.
Okay, so did you
I
make your
made that motion.
I'll second.
I think we're good there. We have a
Yeah.
second? Yeah.
Sorry, did I confuse you?
No, the only thing I wanted to explain is that Lisa was on the summary list for renewals, and she got missed on the resolution that for renewals. So that's why her name appears on this reso as well.
Okay.
That
well,
makes her official.
Thank you, Charlotte.
Thank you.
Want to thank Lisa for re-upping.
Yes.
So all those in favor of of these two applicants being approved for their boards, please say aye.
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 Okay, that passes 5-0.
Sorry, I got that confused.
No worries. Individual consideration items. The first one is an emergency ordinance and resolution confirmatory reading. It is authorizing a SNAP outreach agreement between Hunger Free Colorado and Pitkin County Human Services, and I saw Matt here.
Good afternoon. I'm Matt McGaw, Deputy Director with Human Services. And yes, I'm here today for a confirmatory reading, asking the board to authorize our SNAP outreach agreement with Hunger Free. Pitkin County submitted a plan that included outreach activities. This is a contract that is matched by the federal government that allows us to spend about $52,000 on outreach activities to promote our SNAP program. A reminder that our SNAP program is formerly known as our food stamps. It's food assistance for our citizens who are eligible. And right now, Pitkin County has a caseload of about 260 applicants. And we're really trying to increase our number of applications this year. Last year we had about 350. We're trying to increase that to 400 so that we can hopefully get more people on our program and utilize the services that are there. Last time there were some questions about eligibility, and for this program it's 130% of the poverty level. For elderly and disabled, it's 200% of the poverty level. And I did look that up this time, and so to qualify for this program as a single person, an annual income of $19,391 is where that's at.
Wow.
A family of four, we're looking at an annual income around $39,900. So again, this is one of those programs that it is hard for some of our citizens to qualify for. We really want to do outreach at some of the local medical centers, along with some of our folks that are in employee housing. And so we're just trying to really expand some of those activities so we can increase enrollment.
Matt, is that the poverty level, or is that the 150% of poverty level?
So
39,000.
the first number I gave you was 133% of poverty level.
Okay.
And then for 200% of poverty level, for a single person, it's $29,160 for an annual salary, $2,400 a month. So again, that's pretty challenging for some of our residents to qualify for that. And so we're doing our best to find who's out there and try to get them the benefits that they're eligible for.
Great.
Any questions about our plan or contract?
Steve?
Yeah, Matt, do you have any idea? I mean, you have a goal to increase the numbers, but I think the goal should be to have anyone who qualifies to be able to get the services. Do you have an estimate on the number of people who you think could qualify in the county?
I do not have that number at this point. I do agree with you. It would be nice to know what kind of percentage we're hitting with the eligible population. And so, yeah, that's something I can look into. I'm not sure the best way to determine where everyone's at on the poverty level here in our county.
Yeah, I was curious if 300 is that 10%? Is that 50%?
Right.
How well are we doing? And I guess we don't really know for sure.
Yeah, percentage-wise, it is hard to know that. I think it's one indicator is trying to get more people to apply, and maybe a higher percentage of those will qualify, hopefully. So we are seeing an increase of usage over the last year, although the allotments have gone down. So we're spending nearly about the same, for these programs, but the maximum allotment is $280 for a household. And in Pitkin County, the average household is receiving about $240 worth. So the households here are getting a good percentage of the allotment, but it's, again, just hard for families to qualify.
Yeah. Okay, I'll look for a motion.
Is this a confirmatory hearing?
It is
Yes.
a public hearing. Is there anybody in the public who would, no? It's not a public hearing.
A confirmatory reading is a public hearing.
I wish you would say that.
That is
Is there anybody in the public who would
You're in
like to
charge of
come
the
in?
agenda. Make it say that.
Is there anybody online? Okay, anybody on the board?
I would make a motion to approve this agreement authorizing a SNAP outreach agreement between Hunger Free Colorado and Pitkin County Human Services.
I'll second.
All those in favor, please say aye.
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 Okay, that passes 5-0.
Thank you.
The next one is an emergency ordinance set for confirmatory public hearing on December 6th, 2023. This is an emergency ordinance amending the Pitkin County Code, Titles 5, 6, 8, 9, 10, 11, and 12, to change county code violations from Class 2 petty offenses to civil infractions. And there has been a request for public comment, which will come after Rye's explanation and after Commissioner comments.
Thanks, Francie. Ryan Neely, Assistant County Attorney. going to read the title of the ordinance one more time. It's an emergency ordinance of the Board of County Commissioners of Pickens County, Colorado, amending the Pickens County Code, Titles 5, 6, 8, 9, 10, 11, and 12, to change county code violations from Class 2 petty offenses to civil infractions. There were a number of attachments of the various sections of the code that are being specifically changed that are included in the record. But essentially what I've done, and I got to thank Jeanette and Julia Ely before she left, they went through the entire county code and picked out instances where there was a reference to a Class 2 petty offense so that I could change them to a civil infraction, which was a lot of work, I am sure. The memo includes quite a bit of background about this particular issue, but in short, in 2022, the Colorado General Assembly changed what were previously criminal misdemeanor offenses defined as Class 2 petty offenses to a new category of civil infraction. And that civil infraction comes along generally with monetary fines, but it does not go down on an individual's record as a misdemeanor or a criminal offense. I included a brief statement in the memo about my understanding of why the Colorado, I'm going to get this wrong, I think it's the Colorado Commission on Criminal and Juvenile Justice made this change to address some of the disparate impacts on minorities and low-income Coloradans based on low-level convictions for criminal offenses, specifically things like Class 2 petty offenses and what would otherwise be relatively minor if you could afford to pay the fines associated with the offense.
Can you give us an example of that level of offense?
Sure. Outside of the code, outside of the Pickens County Code, things like having a dog at large or various traffic infractions around the state used to be categorized as misdemeanors. Things like there's all sorts of low-level petty offenses like use of fighting words or various other definitions both in statutory law and various municipal and county code regulations that create classes of misdemeanor offenses that are generally addressed with a fine. But if you are unable to pay the fine or the court costs associated with the criminal charge, there is often an opportunity for an individual to serve up to 90 days to 6 months in county jail associated with depending on exactly what level of petty offense or misdemeanor that individual is charged with. So oftentimes you ended up with Coloradans that were in jail for relatively minor infractions simply because they could not pay. So in 2022, the General Assembly changed the definition in the statute and created, as I said, this new class of civil infraction. To update the county code has, in all these locations that I listed, has references to Class 2 petty offenses for violations of county code ordinances. The county code is implemented and adopted through a legislative scheme that is an ordinance authority of this board. So if for example, the open space and trails regulations are adopted through an ordinance of this board and then set down in Title 12 of the Pickens County Code. And that's where you'll have a fine schedule for violating the various open space and trails regulations. And as you can see, most of the other areas in the code, most of the other titles include references to petty offenses. So this is just a cleanup to come in line with state statute.
I noticed quite a few of those petty offenses had to actually do with pets.
A number of them do, particularly dogs off of leash, dogs running at large, but there's also areas in our STR enforcement, building permit enforcement. The list is
So with the change in
extensive, to say the least.
classification, then these people who do make those mistakes cannot go to jail.
Correct. There's no longer a jail. It's twofold. One is that individual may no longer serve time in jail, and two, their record does not reflect a conviction for a criminal offense, which can affect all sorts of things in a person's life, even their ability to get credit or get a job or you name it. Having a criminal offense on your record can be detrimental to your future ability to succeed.
Do we have questions for Ryan?
I have a question. I'll comment. I think the papers also sometimes publish names of people for these infractions, which can be harmful for your reputation. Can you illustrate the conflict with the court over our treatment of these as petty offenses versus the civil infraction?
Sure. I
language?
think probably the easiest example I can give you from recent times, and because Ms. Anderson is here to comment on the airport stuff, are the Pickens County Code in Title 10, which deals with the airport, classifies a curfew violation, either taking off too early or landing too late out at the airport. It currently classifies it as a Class 2 petty offense. Under the current court system structure, that Class 2 petty offense would be handled by the district attorney's office, who would treat that just as any other criminal trial. The individual who is charged, in this case it was an entity, but if it were an individual, would have the opportunity to appear in court either with or without an attorney, and the district attorney's office would represent the people of the state of Colorado to prosecute that crime against the individual or entity. The legislature, when they adopted the change from Class 2 petty offenses to civil infractions, specifically removed the authority of the district attorney's office to prosecute civil infractions. Instead, the county court judge generally handles the case. And this, as our code continued to refer to petty offenses, when let's say an open space ranger or airport staff would write a violation for the county code, it would come in and the court staff would classify it as a Class 2 petty offense and label it as a misdemeanor case, which the DA's office would supposed to be handling. But statutorily, they're not allowed to handle civil infraction cases. So it created a huge amount of confusion about who was to pursue resolving that particular violation. And there was something else I was going to tell you about that.
Did all Class 2 petty offenses get moved?
I couldn't
into
tell you if every
redefined as
single. I couldn't tell you
infractions?
if every single Class 2 petty offense now became a civil infraction. In fact, I don't believe that's the case. But as relevant to what we're dealing with today, all our county ordinance authority regulations were moved from Class 2 petty offenses to civil infractions. There are, I believe there's other Class 2 petty offenses that did not get changed into civil infractions, but I could be misspeaking about that, but I don't prosecute a whole lot of criminal cases.
And what would our threshold, what would then the threshold be if we think something merits going to court rather than being treated as an infraction?
Sure. And to be clear, the civil infraction process still does go through the court procedure. The district attorney's office just doesn't represent the people in those cases. Unfortunately, that does leave some want of expertise in pursuing some of these violations. And that somewhat existed before this change took place, because it's very unusual for a deputy district attorney who generally handles criminal matters that don't involve the county code to be able to come up to speed on something like an open space violation or a county ordinance violation. They just don't have the background as to why it was adopted and the level of severity that this board may consider the offense and the goals that the regulation was put in place to address. So How it's going to happen now is a bit of up in the air a little bit. The DA's office still won't be handling any of these Class 2 petty offenses. The county attorney's office is not statutorily authorized to enter our appearance in any of these cases. So I can't go in to Judge Andrews' court next door and enter appearance on behalf of the people of the state of Colorado or the Board of County Commissioners to help bring these violations to conclusion with the court. And I know it's caused some very real frustration with the county court judges in our area as to how to handle some of these things. Those civil infractions that are things like speeding or other violations where a peace officer writes a ticket for, let's say, speeding, are so oftentimes simply just paid by the person that is written the ticket that it really doesn't come up that often. When we have some of these more nuanced things like, okay, you have trespassed on a county open space property that also has an underlying easement associated with it, or something like the curfew violation out at the airport that has FAA regulations associated with it in a history that goes back, I think, until 1994, 1993 maybe. Those are where I think it's challenging for the county court judge to know how to address resolving the particular infraction at issue. And I don't have a good answer to that, other than I have long thought, not that I want to take on more stuff, but that there needs to be a legislative change, that the General Assembly needs to specifically authorize county attorneys to enter their appearance on these kind of cases to represent the people of the state of Colorado. There is precedent for that. You'll recall during the COVID-19 pandemic, the county attorney's office was involved with prosecuting some violations of the public health order. That was because there is specific authorization in state statute for the county attorney to enter an appearance in those types of cases. Similarly, in building permit violation types of cases, there is specific statutory authority for the county attorney's office to enter their appearance. The rationale behind that is relatively straightforward. The county attorney's office likely has the resources and the access to county staff that make it easier to pursue these violations in a way that brings them to a meaningful resolution.
So, is our ordinance as it currently stands in conflict with the state statute? Is that
Yes,
why we're
the
here
county
today?
code as currently drafted is in conflict with state law. There is almost certainly, although I believe there is some case law being tested up to the Colorado Supreme Court right now, but there is almost certainly an equal protection violation both under the federal constitution and the state constitution, were this board to have a more severe punishment than what is otherwise authorized by statute.
Okay, thank you, that was very clear.
So I have a question now. So if you can't go to court, who does?
That's part of the problem.
So how, excuse me, but that makes no sense.
It's a conundrum that certainly needs addressing from either the General Assembly or the Colorado Supreme Court Advisory Board on rules for there's a whole separate category of rules for civil infractions that has been created. But it does create a real challenge, and I did speak with Judge Andrews about this in court one day, and it's very difficult because she also doesn't have the expertise to figure out which county employee needs to be subpoenaed to come and prosecute a curfew violation out at the airport.
So how do we cure this? Can we just simply, I mean, it seems like it would be pretty easy if we got the state legislature behind it to fix this and just provide an opportunity for the county to be represented by the county attorney. So maybe that's something we need to discuss with CCI or CCAT or with Perry Will and with Elizabeth to see how we can simply go about doing that. So I think that's something we should probably pursue. Can we do it before we have an issue in front of the court? Or do we have to wait until the time?
There's a whole list of docketed issues right now that are currently county code violations over in the county court right now.
Okay,
And I
so-
keep touch with the staff over there on a regular basis to try and make sure if it is necessary to have an open space ranger or some other county employee come in to be a witness in a case, that I can be there to facilitate that. And I will go to court with the county employee and prep them on what that looks like and talk about what the violation was that they wrote. But that still does not give me the ability to stand up in front of the court and argue the points either of law or fact that would support the violation.
I think it's something that we might want to just pursue.
Is the accused eligible to have representation?
Yes.
Francie.
Thank you.
Yes, great.
You said that it looked like there are two tracks. One was an appeal to the legislature. The other one is to go to the Supreme Court Advisory Committee, or whatever. What did you call them?
Yeah,
And
I
is that
believe,
an
I'm
option?
probably going to get that incorrect, but I believe that there's a rules committee that's associated with the Colorado Supreme Court that could likely also make a recommendation to change the procedural rules to allow a county attorney to, and that might have to happen in coordination with the General Assembly.
Okay, I was wondering if that's a group we could reach out to directly in advance to.
I know that there's other county attorneys' offices that are dealing with this particular issue. As the memo lays out, this was adopted in 2022, and a lot of this is finally coming around as the legislation has been implemented.
So we need to clean up our code to go in context with the state issue now. And then, is Phil Weiser a good contact?
You very
We go
well
right to
may
the
be.
AG, maybe we could,
I'll call Perry and
See which
start
way.
there.
yeah, and let me know what we can do to help with Phil Weiser.
Okay, that sounds good.
Yeah, but I think we need to move this forward, so at least we start the process of cleaning it up, so we're in alignment with the state, and then figure out what the state forgot and how we fix that.
I think it was well-intentioned legislation, they just left out a little part about it.
Operations at the local level
Yes.
tend to get missed.
Yep.
Yeah, so, but
Other
this,
comments or questions before I ask
Yeah.
Ellen up?
this would then, the issue that we had recently with the airport curfew, this would help us so we weren't getting bounced around between courts and courts that didn't even know that was on their docket, and courts that didn't know what to do about it because they never had to deal with it. So hopefully then we can resolve that. So if, in the future, which I hopefully will not have another curfew issue at the airport, it can be a smoother process. Okay, thank you.
All right, well, I'll allow for public comment now. Ellen, would you like to come up?
Yeah, thank you. Ellen Anderson, speaking as a citizen, it is a can of worms, isn't it? And I really want to work with you guys. This is the way I see it. I'll try to be very brief. If you want to change behavior, I think a few things have to happen. First of all, everybody knows the rules. I think all the commercial pilots know the rules. There has to be a perception that there's a high likelihood of getting caught. A perception that, okay, if you do it, you're going to get caught. There has to be sanctions that are immediate. And the sanctions should be appropriate, not draconian. You know, they should be appropriate to the offense. And then some sort of publicity would be great, you know, as crime prevention. But what happened in this case with the, and I'm only speaking for the airport, and I mean, it's so complicated with open space. My heart goes out to you. But I'm just speaking about the airport. Number one, I think everybody did know the rules. The pilot knows the rules. There is not a perception there's a high likelihood you're going to get caught. As far as I know, the only curfew violations that have been reported in the last 5 years have come from me. And I think it's very unlikely that I noticed every single one. The sanctions are not immediate. It took 9-10 months, and we share that frustration. And that the sanctions are appropriate. In this case, I think what happened was the sanctions were not appropriate because a person was not cited, and I understand that an entity could be considered a person under some circumstances. I know that argument can be made. But what happened was there were no appropriate sanctions. SkyWest got cited. SkyWest didn't show up, ever. They got guilty by default, and the only sanction was $1,000 for SkyWest. That is not an appropriate sanction. That's not a deterrent. So that's what my frustration is, and I really want to work with you to try to fix that. I think we all agree we have to keep the curfew, but in this last case, through no fault of yours, just because of the mess that this whole legislative thing is in, we have taught people violate the curfew, and basically you're going to get a $1,000 fine. There's no failure to appear. To me, If you cited a person, there would be the possibility of a failure to appear, and that holds a lot of clout. If you get a bench warrant for a failure to appear and get stopped for running a red light, you're going to get, that's serious. So I have a couple of questions. First of all, I still don't understand why the pilot was not cited, because the county code specifically says the pilot is responsible for obeying the curfew. It specifically says that. The pilot is responsible. So I don't understand why SkyWest was cited instead of the pilot. And number two, from 4 or 5 years ago, when there was a curfew violation that I reported, it went to a county hearing, which was spelled out in the county code. And
30 seconds.
it worked really well. There was a hearing officer. It was Sarah Oates. In the past, it's been Lance Weber and other people. It didn't even go to the county court. I don't understand why we can't reinstitute the county hearing process. And it all is dealt with a hearing within Picken County Code, not with the county the county court. I just don't understand why that couldn't be. I'm trying to simplify it, and I'd also like to offer my help because I really do feel that I am reluctantly an expert in this because I've been dealing with it for so long. And if there's any way, I have all the files, everything, if I can be a resource to you, what happened, and my opinions on how it could be solved, I really think I could help you, and I'd be happy to do that.
Thank you, Ellen.
Can I just real quick?
Yes.
Isn't there an issue with the $1,000 that we tried to adjust and we got nowhere? Weren't we trying to raise that, allow that $1,000 fine to be more significant? And we tried to do it. It had to be done through the state legislature, and we didn't get anywhere.
Yeah, it seems, if I remember correctly,
Couple
Patty,
years
I think
back.
we did it through a CCI legislative
Yeah.
issue and did not get support.
Yeah.
I'm trying to
So
remember the
we tried in the
specifics of
past to
that.
get there.
I can talk to that a little bit. The statute limits a code violation fine to $1,000. And
chump change.
yeah, agreed. And we've brought that forward through our statewide associations. The message said back to Picken County was, we can understand your problem, but it's not broad enough for us to provide state support on this topic because it's sort of limited to you guys. So you guys should do what you can to change that. And we have had conversations with our legislators about this. It just hasn't sort of risen to the level of a priority. I'm hopeful that's changing because there now is a broader conversation with other jurisdictions across the state wanting to revise how county code violations are dealt with and giving more flexibility to local governments. And so that is a bill topic that's being discussed and is being shopped around for legislative support. And we see that as the best opportunity to try and raise the fine limit, which is not.
In terms of the curfew, is there some reason not to adjudicate under the county hearing?
Oh, I can't answer that.
We'd have to discuss that as part of this process. I think.
Maybe, Ra, you could get back to Ellen to answer a couple of her questions.
course.
Yeah, thank you.
No problem.
Thanks, Ellen.
Yeah.
Thank you, Ellen.
Right, if I could, Francie, just the question about why the airline and not the pilot was cited is an interesting one, and I'd love to hear about that as well.
Sure. The codes provides that either the pilot or in the case of a commercial airline, the commercial airline can be fined in connection with the offense. We have had instances in the past where a GA pilot violated the curfew, and we were luckily able to serve that person next time they landed in Picken County. You do need to hand a summons to appear in court in person, either from a sheriff's deputy or an authorized representative to do that. So functionally speaking, at least with this last airport violation, it's quite a bit easier to serve the summons on the SkyWest representative who has an office out at Picken County than that individual pilot who flew in there on that day. Now, I don't disagree with Ms. Anderson that perhaps doing that and serving that pilot, it would not have been impossible to do. It would have been challenging to find out when he was scheduled to fly in here next time, but it would not have been impossible. May have had more of a deterrent effect in the future. I don't know the answer to that for sure, but it is something that can happen.
Can you specify in the FBO contract that the process server works at the front desk?
Ultimately, the violation, the code calls out, I believe if a commercial operator has 4 violations in any given calendar year, their ability to utilize the Picken County Airport is jeopardized by that.
Keep watching
And
them
you
out.
could change that if we wanted to a code change.
Right.
So, and to Ms. Anderson's other point, if we wanted to use a hearing officer process, that's a legislative change you all could make as well. So,
Thank you.
Any other questions or comments? Would somebody like to make a motion so that we can be in sync with the state at this time?
I'll make a motion to approve an emergency ordinance of the Board of Commissioners amending the Picken Code Titles 5, 6, 8, 9, 10, 11, and 12 to change county code violations from Class 2 petty offenses to civil infractions set for confirmatory reading and public comment on December the 6th.
I'll second.
All those in favor, please say aye.
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 Thank you. Thanks,
Aye.
Alan.
Okay. The next one is a one reading resolution of the Board of County Commissioners appointing a Picken County Board of Appeals. And Rye's going to present that as well.
yep. I'll try and be, this one I know you have a bunch of other stuff today. So, oh, and Steve, I sent you an email with this draft resolution. I appreciate the board's patience. I didn't have time to get this in the packet last week, but we do have some folks pursuing an appeal of a determination made by the Picken County Chief Building Official. So I needed to get this in front of you all to get the Board of Appeals appointed. The Board of Appeals is statutorily authorized to hear appeals from Picken County building official decisions. They're largely administrative decisions in applying the Picken County Building Code. The Picken County Home Rule Charter specifies that there shall be a Picken County Board of Appeals. And as we were addressing this appeal that is pending, we realized that there had not been a full Board of Appeals appointed by the BOCC in some time. So that's what this resolution does. These individuals here are on a joint Board of Appeals that we share with the city of Aspen. And these 5 individuals, Wayne Stryker, William Argero, Sarah Broughton, Greg Woods, Stuart Bohart, and Thomas Marshall, who I've got listed as an alternate here. The joint board is 7 members, but the Picken County Code calls out 5. In any event, these are the individuals that have volunteered to do this. I haven't spoken with them individually, but they've volunteered to be on the joint Board of Appeals. So what all this resolution is doing is having you all appoint these individuals, which will give them the jurisdiction to hear the appeal that is pending right now from the building department. I'd be happy to answer any questions about this if you have them.
So did we not have any appeals pending before, and that's why we didn't have a current board?
I was trying to think back to the last time we had, so this is different than an appeal from the Picken County Land Use Code, which you all are familiar with. This is specifically appeals from a determination of the chief building official or the building department, and it's pretty rare that we have these. I think when Brian Paul was the chief building official, I might have done one of these with him in like 2016 or something like this. And that's one of the reasons why I believe we share a joint group with the city, so that because it is so infrequent that you hear that the Board of Appeals needs to be constituted and have a meeting, it would be like once every couple years. I think it's once every couple years as things stand now.
Okay. Yes, Dawn?
What is the next level of recourse after this Board of Appeals?
I believe most likely a judicial process, a Rule 106 action or something like that in the district court.
So does it, these won't come before us, but we would obviously be advised should it get to the courts.
Once it gets to the courts, you would be advised.
Okay.
I just
Many
wanted to
thanks to
thank
those who
everybody who stepped up
volunteered.
to volunteer to do this. These are locals who are paying attention and involved in the community, and I just want to thank them.
And is this a one read? Do we have public hearing?
Sure.
What did you ask?
It's one reading. Do we have a public
It's an
hearing? And he
informal
said sure.
resolution. Technically, it's not a public hearing. If the board
we
wants
can
to
if we
take a
want to.
public comment, you can.
Is there anybody here to comment on this? Okay, then.
Well, since I already kind of made a motion to approve this, I'll do it again. I'm going to make a motion to approve a resolution of the Board of County Commissioners appointing the Pickens County Board of Appeals. And thank the people
I'll
who have
second.
volunteered.
All those in favor, please say aye.
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 Thanks, Rye.
Thank you.
Passes 5-0. Okay, now we have a public hearing, individual consideration items. Second readings, the ordinance of the Board of County Commissioners of Pickens County accepting an encroachment license from the Roaring Fork Transit Agency for the purpose of constructing the Aspen Village Gerbosdale pedestrian bridge. And Dale will present this to us. It was continued from October 25th.
Hi, Francie.
Hi,
I'm
Dale.
Dale Will with the Acquisition Director for Pickens County Open Space. And this is just one of the pieces that we need to construct this bridge. This is, as it's described, a license agreement with RAFTA. And of course, RAFTA has to be very careful about the ways in which it allows construction within the rail corridor, since it is rail banked. And we managed to work that out with them. This project has been a long time in coming. Gary came down to help me talk about the project itself. So I will let him do that.
Sure. Hello, everyone.
Hi, Gary.
I'm Gary Tenenbaum, the director of
Glad to
Open
see you
Space and
here
Trails.
healthy.
Yes, it was a pretty mild case, so.
No
all
mask or anything. Wow, we've really
I've tested
moved on.
negative.
Dale moves
I
back.
tested negative on Sunday, so, and
Awesome.
Monday, and so, totally good.
Alrighty.
So the project, we were out to bid. We actually had, I think, 7 or 8 contractors come to a mandatory pre-bid yesterday.
Great.
So hopefully that turns into 7 or 8 bids on this. We'll see. But anyway, it is out the bid, and we are fully intending to get this under contract. And we'll see with what the construction time for a bridge will be. But that's going to depend on, that's really going to take us probably into a fall installation. But we'll see. We'll see what happens. But we're moving forward with it, and we'll definitely have a big ribbon cutting, and all the Stutzmans will be, Dolores Stutzman has been on my case for, I started in 2022, and she called me in 2023.
She was on me
Oh,
before
2003.
that, 2020.
Yeah.
2003.
In 2003, she called me and was like, "We need a bridge here," and sadly, she won't be there, but the family will be.
She
excited.
called me in 2000.
She did. Yeah.
So I want to thank you. Francie, may I? I want to thank you for pursuing this, for your diligence, and for in honor of Dolores Stutzman. We're going to get it done.
Well, and the beauty is once we proposed it to the Aspen Village residents, they were just, I mean, they took it upon themselves to do videos, and they kind of did the public process for us. It is unusual, because Lazy Glen was a much more difficult, we had more of a language barrier with a lot of people, and that was more difficult. But with Aspen Village, that whole community was just like, yes, please, let's make this happen.
Great.
And
Thank you.
And there's a lot of people, I didn't realize how many people live back there. It's over 300, so
Yeah,
it's impressive.
Over 300 people live there.
Yeah,
I'll be darned.
yeah. If you pull up in there, you go, wow, there's a lot
And
of
it keeps
houses.
going and going.
Yeah,
Try walking
it's-
it for
I
elections.
know, you can walk it next year with me.
There you go. Nice.
would you mind if, just because it's in the packet, about what the Rio Grande right-of-way rail banking means, I think it's important that we articulate this from time to time. I know RAFTA would appreciate it when we do. That the Rio Grande right-of-way is rail banked in accordance with federal rails to trails legislation. So the county understands the trail uses are subservient to potential rail uses, and that we agree that any trail-related improvements will be relocated or removed for potential rail uses in the future, if and when that happens. And that corridor is, I believe, is about 100 feet wide, all the way up the Rio Grande. I believe it's 100-foot wide with deviations, right?
Yeah.
I was looking for that word, deviation.
Right, yeah, it's not, I think the ambition
That's
was
what
that it'd be
this
100
was.
feet wide. It probably isn't in all cases. But I think it's good to remind people of that was the original purpose, and it's such a great popular bike and hiking path. But we have to keep in mind that that could be a transportation corridor someday, if autonomous drone taxis don't take over before the trains get here.
We know where Greg would want to go on that one.
Any other comments or questions for Gary or Dale?
I have another quick question. So we continued it last time because of noticing. There wasn't a change that needed to be made. So we're clean on this one. Okay.
Anybody want to make a motion?
It's a public hearing, isn't it?
Oh,
Yeah, it's public comment.
Yes, is there anybody in the public? This is a public hearing. I'm going to open the public hearing.
Thank you, Francie.
Is there anybody in the public? Yes, Ellen, come up.
Yes, Ellen Anderson. I lived in Aspen Village since 1979, and I want to thank you so much. On a sad note, you may recall that we did have a fatality of somebody trying to navigate the system. Denny Sukarik was killed on a bicycle, trying to navigate exactly where this path will now be safer. I remember being terrified with my young child, trying to, get down to the Rio Grande Trail. And thank you so much. So much. I really appreciate it. And now my grandchildren will be safer. And I also want to give a big shout out to Kate Spencer of Aspen Village, Dr. Kate Spencer, who's really been a force behind this. So this is just a very happy collaboration. And from the bottom of my heart, thank you.
Thanks,
Thank you, Ellen. Is there anybody else in the public who would like to comment? I think I heard a motion.
I was beginning it that we accept an encroachment license from Roaring Fork Transit Agency for the purposes of constructing the Aspen Village Jerbozdale pedestrian bridge.
And I'll second it with a really quick comment, if it's okay. I also want to mention that I'm still working with a young Eagle Scout candidate to do an Eagle Scout project at the bridge in honor of Dolores Stutzman. So I'm working with Open Space and Trails and with the Eagle Scout and his family, Eagle Scout candidate and his family, like we did out here in Veterans Park. So somehow I've become the appointed Eagle Scout candidate go-to person. So we're still working on that. So thanks, guys.
Do we have a second?
I did second.
Okay, well, all those in favor, please say aye.
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 Thanks, guys.
Aye.
Okay. And Dale has another thing for us. It's an ordinance by the Board of County Commissioners authorizing the purchase of a conservation easement from Aspen Valley Land Trust on the back 80 parcel.
We are,
Because you just approved the budget, and I want to explain, a little bit about it. So, Anjanette Rosas Garcia is our new joint community engagement coordinator, manager with AVLT. And so we are doing, you guys have helped fund this position, and it's through AVLT, and we're really excited. Anjanette is awesome. She's already jumped in and is already doing incredible stuff, trying to get our, the conservation world and trying to connect with our diverse communities in this valley has been difficult for us. And so with you guys' funding and the AVLT's funding, we now have a position to do that. And we're really excited to see where that goes. So anyway, I just wanted to introduce her because you haven't met her yet. She's relatively new, but it's been 3 months.
I started September 5th.
Right,
So-
and I'll let her introduce the rest, because she is.
So she's a Picken County employee, not an ABLT?
No,
No.
we have, the way we have structured this. Well,
Well, I'm glad I asked.
well, it's, the reason why we did this, because it is sometimes very difficult for government to engage in these communities. And so we are trying this new approach where, you know, we do this a lot with other organizations, Roaring Fork Conservancy, ACES, and RFOV. We sponsor and help fund their programming to help us. And so we're hoping that this position will help us too, because in a way, you know, we work with ABLT, we help manage this position, and we're using it to help engage in the Latino and other diverse communities to really kind of get people knowledgeable about our properties, about conservation. And so that's why it's a good question to ask. That's why we didn't want to house it within Picken County, because I really felt that the nonprofit potentially has an easier way into these communities. And we'll see. We'll see how it goes. And we'll keep reporting back yearly. But we're excited that we found somebody, and we found somebody with a lot of good qualification to do this.
So you're an employee of ABLT?
It's a shared position, but yes, I am based at the ABLT office in Carbondale.
And that's supported by OST?
Right.
Well, it's
That-
jointly funded by both organizations.
Yeah, okay, I get it now.
So the
Welcome.
question would be, if I might ask, what happens if we don't agree on something?
But that will never, ever happen.
She sides with us.
I remember it happening in the past.
But
We'll
the
work
good,
on it, we'll work on it.
I think right now, this is one of those things where our relationship with AVLT is one of the strongest in the valley. I mean, we're at the same level as, you know, our relationship with ACES and Roaring Fork Conservancy, and yeah, we always have disagreements with our partners, but you know, I think in this case, I think we're going to agree, because what she's trying to accomplish is something that we've all been trying to accomplish for years. And
We can work on it.
Yeah. And Patty, I would also encourage another question is what will happen when we do agree? And in those opportunities, there's such an amazing opportunity to share connections, share relationships, sharing of space, and those are the opportunities I'm really excited for.
Yeah, we can't wait to see what's happening with properties such as this one and like with Kaufman and where we might
Yeah.
go. It's really cool.
Right, and I'm so excited to meet all of you in person and just
Yeah, you too.
express my gratitude.
Could you remind me of your name again, please?
My name is Anjanette Rosas Garcia.
Okay, thank you.
Yeah.
I didn't say it so perfectly like that. Rosa,
You did
you need
okay.
to get
I
down to
really
Rosas.
appreciate everyone has a name tag. Oh, fancy.
Yeah, bring yours next time.
Yeah.
And I want to add really quickly, just so you know, because I think I've added this before, the Kaufman Project was my grandson's first volunteer effort. That's right. And I think he was 6. I think he was 6 years old. Could have been 6 or 7. He's 8 now, so a year ago, maybe 2 years ago, yeah? And he was very proud of himself for going out there and volunteering.
Wow.
It was very cool. So getting those young people involved is important.
And Jeanette is joined by.
Hi, I'm Carly Bolliger. I am the Communication and Engagement Director at Aspen Valley Land Trust, so working closely with Ann Jeanette, and would also just echo everything that you said, Gary. It has been a short time that since you've started, Ann Jeanette, but she is hitting the ground running, and this project that we're here to talk about today is a great example of where she will really plug in and be able to connect more of our community to our beautiful open spaces, jointly protected by AVLT and Pitkin County. So we're super, super grateful to be here, and I'll let you take it, Dale.
Great. Well, this is second reading, and we had a nice chat about this property at first reading, so I won't go through everything except to briefly mention that this is really a piece of a project that we finished the acquisition part about 6 weeks ago when we closed on the conservation easement that Pitkin County acquired on the Outward Bound campus, now known as Base Camp West. And we funded that conservation easement for the purpose of helping to fund the preservation of the Outward Bound campus as something that could continue to be utilized for outdoor ed for all of our Valley residents. And the amazing thing about that project was how well funded it was by various Aspen entities, not just us, but the Aspen School District and the Aspen Parks Department. The piece of property that we're here to talk about specifically today is 80 acres of wildland that's contiguous to the Outward Bound property, and the uses that are contemplated there are really kind of different, although there's going to be a little bit of overlap. But once again, we are acquiring a conservation easement as part of a larger project to acquire this piece of land to become part of the Base Camp West assemblage. The purpose of this acquisition is a little different, which is to keep it quiet and to prevent any activity there that's really inconsistent with the goals of the Outward Bound Base Camp West project. The property is zoned up there, I guess, commercial, and under the somewhat Wild West land use laws of the Upper Crystal, things could have gone on there that would have really been difficult to manage side by side with Base Camp West. So we have drafted a conservation easement. It's in the packet. The emphasis of this easement is on habitat preservation, and the idea being that this property will be quiet during the winter months when the animals are all under stress, similar to what we do at Sky Mountain Park and other places. There's a limited amount of recreational and educational activities that would go on there in the summer when Base Camp West is in operation, but essentially creates a big buffer for Base Camp West and protects some very critical habitat up on Daniels Hill. The Roaring Fork Watershed Biodiversity Initiative recently identified that whole hillside as a critical piece of winter habitat, which is within, not quite a stone's throw, but within line of sight from all the high peaks in Pitkin County and the Elk Range. So we are very happy to be bringing this back. It was unanimously recommended by Open Space and Trails. And we're also very happy to be continuing this partnership with AVLT, trying to protect important conservation lands in the watershed, and their partnership, I guess from a parochial point of view, enables us to strategically extend our reach into these environs that are important to us, but slightly outside of our jurisdictional line for our county.
I have a question about, a general question, not specifically about this piece of property, but when I was at Kaufman's vaccinating calves on Saturday, I think it was Saturday, I noticed again that there is a big sign about AVLT there, and it doesn't mention Pitkin County, and I'm wondering why.
Well, long ago, a county commissioner candidate had this campaign sign that I've always loved that's quoted Harry Truman saying, it's amazing what you can do when you aren't interested in who's getting the credit.
It's amazing what you can accomplish when you do not care who gets the credit.
I guess so. That's my personal quip about that. But Carly,
as the communications director, I'm happy to chime in. We tend to put little GoCo plaques up whenever they've supported a project, and we would definitely be happy to do something similar.
Well, I don't know how other people feel. I'm just surprised that it doesn't show up. Also on your website, it doesn't really show up much either. And I just, it's a big deal. It's a lot of money that the taxpayers of Pitkin County spend outside of their jurisdiction. And I think, you know, I don't think we care particularly, but I do think that there are taxpayers whose money is being used to protect land outside of Pitkin County who might like to see, oh, look what Pitkin County did when they drive up Catherine Store Road, you know.
Yeah, definitely. Yeah, definitely something we could explore, and we'd be happy to give recognition where recognition is definitely due.
Correct.
On that note, it would be great if the sign actually said paid for in part by donations from Pitkin County taxpayers or
something like that.
something
Just
to
open
that
space
effect.
and trails.
So it's not us, but it's the taxpayers. That would be great, through open space and trails. You guys figure that out.
Well, and
Thanks
that's-
for
yeah.
bringing it up.
And the reality is too, is that sign is temporary. That just
It is
got, I
temporary.
mean, it's. you
On the
know,
permanent
yeah,
sign.
Yeah.
We are exploring some more informational signage once you're at the ranch that has a lot more detail, and so that will definitely refer to Pitkin County, but we could definitely collaborate further for that specific language or recognition.
And I'm not asking you to overdo it with interpretive signage. That's something I can't stand. But it'd be nice, somewhere.
Have to meet
Steve has his hand up too.
Yeah, I know he does. I'm going to call on. 1 second, Steve. I just got one more thing to say on this, and that is, it might also act as an inspiration for other counties to consider contributing more. Steve?
Well, I don't think we should be putting all this information on a sign out on the Garfield County right of way.
It's on the property. It's not on the right of way.
Somebody's gonna have an accident trying to read a sign there with too much wording on it and run into the ditch and through the fence, the really nice fence that Kaufman Ranch has. Putting something inside the property, I think, would be a very appropriate place to give recognition and credit to those who helped purchase the property.
Yeah, the sign is inside the property.
Yeah, and on the other side of this, there are people out there who are upset with us for spending money outside of Pitkin County.
I
So,
think fewer.
yeah. Next time I hear from them, I'll send them to you.
Can I ask one other question just of Dale and Gary? Can you speak very briefly about the value of joint holders, joint ownership of conservation easements or conservation properties?
I'd love to. It's been a passion of mine since I started in the last century in
2000.
1999,
We hired
working
you,
with all of
my
you on
first
all
hire.
this. But I feel that the more eyes on stewardship of land, the better, and both from a point of view of the actual on-the-ground boots and shovels kind of things, but also the legal eyes on protecting these things. So by co-holding things or by splitting up, in this case, ownership of the fee simple interest with us holding a conservation easement, we've done a lot of vice versa, and we also co-hold a lot of conservation easements. I think it just increases the likelihood that at some point in the future, if you imagine your favorite, Mad Max end of the world scenario, I think it increases the likelihood that there's going to be somebody there that's going to want to step up and protect the open lands, which is what we're all about. So, we craft these co-holding agreements very carefully, and there's a lot of behind-the-scenes work that goes on with RI and AVLT's council and our staffs and so on. But as Gary just mentioned, the outcome is just great. I mean, in a sense, we've enrolled more people in enjoying the protection of this place.
Thank you. Just what I wanted to hear.
Good
Any
way to
other
get-
questions?
Good way to get the word out there.
I suspect this isn't going to be difficult. Anybody want to make a motion? Oh, no, it's a public hearing, so let's be sure the public would like to comment. Yes.
Well, I want to make sure we gave AVLT ample opportunity to say whatever they want to say about this project as well.
Yeah, I feel like you covered it pretty well, but I just would like to reiterate that we are super grateful for that partnership. I think that we really specifically benefit as well with our partners, and we have really ambitious conservation goals that we know are attainable, but only attainable with our partnerships such as Pitkin County. And so I think I've been with AVLT for 3.5 years, and just watching that relationship grow and the investments grow and how much the impact then quadruples is really powerful. And so we're just really grateful for all of OST's investment and partnership in this, and getting the opportunity to purchase the former Outward Bound property this fall was pretty monumental for us and doubled our outdoor education facility in Marble, and this will again double that. So you're talking about some serious acreage for elk and kids, which is amazing.
Thank you.
All right, now I'm going to open the public hearing. Is there anybody in the public who would like to comment on the purchase of a conservation easement on the back 80 parcel? Doesn't look like it. Anybody online? All right, I'm going to close the public hearing on that and bring it back to the board for more comments or a motion.
I would love to make a motion due to a lot of my family history on this property with my brother-in-law, Willard Clapper, and all the family members and local students who participated in activities up there. It's pretty amazing. I'm going to make a motion to approve an ordinance of the Board of County Commissioners authorizing purchase of a conservation easement from the Aspen Valley Land Trust for the back 80 property.
I'll second that.
All those in favor, please say aye.
Aye.
And
Aye.
thank you. And it
And
was
many
really
thanks
nice
to the
meet you.
family for working with all of us,
Yeah.
all of you.
Thank you, guys. Thanks for coming in today.
Thank you.
It's
Good
great
to
to
see
meet
you,
all
Carly.
of you and
Can
see
we
you again
take a
soon.
really short break between this and the next item?
Sure,
Is
we'll
it
take
gonna
a
be
5-minute break. Grassroots will be back at 1:15. We're going to take a short break. Good afternoon and welcome back to the Wednesday, November 15th regular meeting of the Pitkin County Board of Commissioners. I know there's quite a few of you online. I saw your names. So welcome, and welcome to those in the room. Thank you for showing up. We have number 7. This is a land use public hearing. It's an ordinance of the Board of County Commissioners adopting text amendments to the 2006 Pitkin County Land Use Code, Title 8 of the Pitkin County Code. And just for the public, we're going to go through all of the ordinances and then open the public hearing after that.
Great, thanks, Francie. Suzanne Wolf with Community Development. Hannah Hunt Muller is here to help me run the show, and Kara Silbernagel from the manager's office, and Kara gets to kick it off, and then I'll step in. Actually, maybe before Kara goes, I'll just say, because today's the public hearing, we're going to run back through, the presentation will look very similar to what you saw on first reading, but we thought it would be helpful for the public to kind of run through all of the same slides we did last time. So we'll, you'll be seeing things twice, but it'll help keep it fresh for everyone.
We can handle that.
All right, so quick, just to kick us off, thank you, Suzanne, of why we are here today is, as everyone is pretty familiar with at this point, the Community Growth Advisory Committee was set up. 10 months of work came up with amazing recommendations, and staff was asked to look at what are some early action, some short-term pieces that we can do now in order to really do due diligence for the growth committee recommendations. And this is at that September meeting when we presented different options for the board. This is really the board's comments of and direction to staff of we need to do something now because we are in a climate emergency, but we remain very committed to the implementation of all of the committee's recommendations. Next slide. So somewhat summarized it, but the board declared an emergency, a climate emergency in 2019, established the Growth Advisory Committee. They spent 10 months, 21 meetings, and really came up with some great recommendations. Presented those to the BOCC and P&Z in June, and that is when staff then came back to board and presented some phasing options. At that time, that is when the board directed staff to move forward to P&Z, and since from there back to the board, of bringing forward a 9250 house size cap limit across the county as step 1 while continuing to move forward with the growth committee recommendations for that early action option for the time being. Anything else? So with that, I am going to hand it back over to Suzanne.
Thanks, Kara. We've been to the P&Z. Today we're going to talk about land use code text amendments and rezonings for overlay zone districts. So we can go to the next slide. The P&Z on October 17th adopted amendments to the comprehensive plan. They also made recommendations to the BOCC regarding the land use code text and zoning amendments that are in front of you. The BOCC approved the amendments on first reading on October 25th. So today is the second reading and public hearing. And as you noted, Francie, there are 6 ordinances in front of you to accomplish all of this. The text amendments, and then the overlays, one for the 9250 countywide overlay, and then 4 overlay zone districts, and we'll walk through the details on all of those. So again, I think for the P&Z, we covered that. So again, the land use code text amendments are establishing the countywide 9250 final maximum floor area limit and creating 4 new overlay zone districts. Brush Creek, Emma, Valleys of the Capitol Creek and Lower Snowmass Creek, and the Basalt Urban Growth Boundary. 2 of those, just backtrack for a sec, 2 of those, I guess we'll get into that when we get into the detail on each of those. So just we're creating overlay zone districts as part of this.
Can I interject something very briefly? Just when you mentioned Brush Creek, that's my neighborhood. I'm a Brush Creek resident. I just want the public to understand that I had absolutely no connection with the decision by the HOA, regarding, or the caucus regarding this decision. Didn't participate in it. In fact, I felt guilty that I didn't. And it occurs to me, Steve is in the Snowmass Cap. I don't know if he participated or not, but I just want people to understand that this was a decision that was not in any way influenced by me, to my knowledge. Thank you.
So I did participate at a certain level with our caucus, but that was mainly consulting with my wife, Molly, who is a board member on the caucus, and just to help her understand the nuances of it. So it was more almost a family affair. I did answer for the caucus some technical questions when they would ask me when I would be at their meetings, just about the land use code and, you know, various technical things.
Thank you.
Thank you. So the 92 square foot final maximum floor area would apply to all lands within unincorporated Pitkin County unless there's a more restrictive standard. So obviously we have zone districts like rural remote that are more restrictive. There's zone districts that have a floor area ratio that may result in a lesser final maximum floor area. And then we have overlay zone districts, two that exist in the code today, Maroon Creek in the Frying Pan, and then again, we're creating the 4 new overlay zone districts, Emma, Brush Creek, Basalt UGB, and the capital Lower Snowmass Creek. That's the technical piece of the actual sections of the code that are being amended. Kind of move on from there. And then this is the map that is basically showing the entirety of the county, calling out those overlay zone district areas that will have a different limit, and else basically everywhere else in the county is subject to that 9250 square foot limitation. So now we'll walk through each of the different overlay zone districts. First being Brush Creek. Brush Creek adopted a master plan that recommended a 5750 square foot house size limitation that's supported through various issues in the master plan. So by doing these amendments, we would create a new overlay zone district in the code, and we would rezone all lands within the boundaries of the Brush Creek master plan area to that overlay zone district. And all properties within that area would then be subject to the 5750 square foot limit. And so then the next slide just shows that Brush Creek master plan area and the underlying zoning. Again, just for a reminder for everyone, an overlay zone district, you still have your underlying zone district, say AR10, and the overlay applies in addition to that. And the overlay can implement additional restrictions or, in this case, the floor area limit. So that's what's being accomplished. So then again, the Emma overlay, the Emma area in the code has had an 8,250 square foot limitation for a number of years, which was to implement their master plan. I think that was the 2014 master plan. But we didn't at that time create an overlay zone district. So again, we're kind of finalizing that additional step to create the overlay for that area. We did get comments from the Emma caucus, which were included in the packet. And the concern there was the representation in the code about 5750 and the opportunity to go up to 8250. And they really wanted the language to be clear that their master plan had said, use the language of exceptional circumstances. Only in exceptional circumstances would someone be able to use a TDR or compete in growth management to go up to 8250. So we'd have amended the language in the ordinance to capture some of that language and be a little bit more specific. Again, the options are still there. Nothing has changed in Emma. It's still an 8250 final maximum floor area. But you would either go through special review to land a TDR or the growth management competition process in order to even go up to 52 or 8250. So again, we did change some of that language in response to the caucus's comments. So then that next slide shows the Emma area that would be subject to the overlay as well as the underlying zoning there.
Clarifying question, what you just said. So has that been the circumstance where they go through special review now for a TDR?
Yes.
I don't know if we've seen
In Emma.
those. Yeah. I guess
The
the
special
there's
review to
some
land a
historic
TDR is
purpose.
set up as a hearing officer approval.
Got
So,
it.
right, they don't all come to you.
That makes sense. Thank you.
Yep. Okay. So next, Valleys of Capitol Creek and Lower Snowmass Creek Overlay Zone District. Again, there's a recent update to their master plan that recommended a maximum house size limitation of 5,750. So we're creating the overlay now to accomplish that, and rezoning the areas within that boundary as well. And again, a map for that area as well with the underlying zoning and what property would be subject to the overlay. And then last is the Basalt Urban Growth Boundary Overlay Zone District. And this again is one like Emma where the restriction of 5750 has existed in the code already, but we had not created an overlay zone district to affect that limitation. So this adds that additional layer of an overlay to that area. And this one's the very unusual map that we saw last time. So again, we're talking about areas within the Basalt Urban Growth Boundary, but only in the unincorporated area. So that are the little slivers in green, and the one purple piece, which is zoned MHP, which is part of the Roaring Fork Mobile Home Park, are the areas that would be subject to the overlay zone district. Okay. So then, again, the 9250 overlay would apply countywide with the exception of these areas within overlay zone districts. And then there are some areas of the county, Star Mesa, Eagle Pines, and the Preserve subdivision, which are already specified in the code as having limitations that exceed 9250 based on prior settlement agreements. And so those are also called out as not subject to the 9250 limit. And again, same map that you saw before. And that just shows you all the underlying zone district throughout the county, which is really hard to read, but but putting the overlay and that all together is really illegible. So just the two separate maps to show those. Okay. Okay, so on first reading, a lot of your discussion time was spent on this topic. How will these regulations apply? The P&Z had made their recommendation to you, which you all had a pretty lengthy discussion about. And on first reading, agreed that the proposed regulations would not apply to the following: land use applications with vested rights, land use applications submitted and deemed complete, awarded and unexpired GMQS allotments if the commitments made in the GMQS competition have been satisfied. You also had a lot of debate and discussion about whether the regulations would apply to properties where a TDR has been extinguished, but not all the floor area from that TDR has been utilized. Right now, the draft ordinance allows use of the remaining floor area from a TDR, even if the resulting development would exceed the applicable final maximum floor area, which would be the 9250 or the overlay zone district limit.
Would you remind us about how many situations have that?
I'm going to get there. We have some data for you when we
Great.
run through this. So we
Thank
have
you.
it for both growth management and TDR. So we'll get there.
Thank you.
So this is a lot of text, but I just thought it would be helpful to put, this is the actual language out of the ordinance that affects what I just summarized on the prior slide.
Just a question, will this show up, does this show up then in every overlay, or is this in a
So
applicant?
the applicability shows up in the ordinance that, for the text amendments. It does not, it's not necessary to put it into the separate rezoning ordinances because it's the applicability of the text in the land use code.
Yeah,
So while you're saying that, let's clarify. So when we vote on this first ordinance, we're voting to change the text to reflect these changes. And in the ordinances that follow, we're voting to implement those. Is that correct?
So, right, the first ordinance, right, changes the text in the land use code, in the text in the code. This following ordinance is actually rezone. We need to change the text of the ordinance to create an overlay zone district. So then we can actually rezone something to that overlay zone
Okay.
district.
Thank
So that's then the 5 subsequent are the actual then rezonings of those areas.
Okay.
So again, these 3 slides, I just wanted to put the detailed language up. It's a lot to digest, obviously, off a slide. It's in the packet, but I just thought it might be helpful for the public. So there are 3 slides that basically show the exact language that was put in the ordinance. This is the unexpired growth management
Can you
allotments.
leave it there for 1 second? Okay, thanks.
And then the 3rd slide is the language about TDRs, where a TDR has been extinguished, but maybe not all of the floor area has been utilized. And again, each one of these says the provisions of this ordinance shall not apply to. So these are the things that are not affected by the changes to the text.
So can I add on to your question? So then at the very end, when we get to the finale, we do the house size. Why aren't we doing that before we do the rezoning, since the house size is why we're rezoning?
Because the final ordinance, you have to kind of go sequentially. We have to create the language in the code. We're rezoning areas to those overlay zone districts, which
Right.
have more restrictive final maximum
Right.
floor areas. And then in the end, the final ordinance is saying we're rezoning everything else that is not within these overlay zones.
To the
So we need those areas to be rezoned.
Just want to make sure we're
So yes.
getting in the
I
right
had
order.
I had to
Thank
think
you.
that one through to make sure I got the sequence right, but, but yes. So, again, I think if you want, just to, back to this, again, I said, this is the language that the provisions shall not apply to. So is it helpful for me to say, then that means here are things that this will apply to?
I
Or
get
will
it.
that make it more confusing for you at this point?
I get it the way it is.
Okay.
get it the way it is.
Because
Everybody else.
okay, perfect,
These are the things that could be bumped over 9250.
correct.
Thank
Okay.
you.
It's not the end of 15,000 square foot houses, in other words. Not quite the end.
Okay.
We're getting closer.
All right, so then, this was just, an item, again, that came up from the P&Z, the recommendation that we will be creating non-conforming situations, the discussion that our current regulations for non-conforming structures are clunky was the word I pulled out of one of from the meetings, and potentially burdensome, as, some of the comments we've heard. So the P&Z had recommended that you direct staff to draft amendments to the non-conforming regulations as a priority in the near term. So again, there are no changes to the non-conforming provisions as part of these ordinances today, but I didn't want to lose track of this. Again, the P&Z was looking for you all to give staff direction to pursue that, again, in the near term, as opposed to waiting while we work through, the rest of the Growth Committee's recommendations.
Do you feel like you
as
have that direction?
part of that package.
Yeah, I think we direct, I think.
Yeah,
Okay.
just making sure.
Just
that
wanted-
we-
okay.
What's
Yeah,
the
I-
near term for you?
Can I?
6
can I-
months?
Mm.
8, 9 months?
She's not committing.
Okay, just
I hadn't thought that through yet, but I
Okay,
mean,
all right.
but again,
No
I think
pressure,
we're
but
clear
we-
that, right,
okay.
we're bringing that back as soon as we can spend the time to figure out what we need to work on with that, so,
Okay,
again.
Patty.
I have a question, not to further belabor things, but not to go backwards, but I'm going backwards. With the TDR issue, so does that mean existing TDRs? What happens if somebody purchases a TDR after this process is completed and only they can't use that TDR to exceed the 9250?
Correct.
Okay, so it's ones that are already purchased, already existed, already extinguished, la di da.
Right, essentially, it's really limited to someone who has extinguished a
already
TDR with a
done.
specific building permit, but there was floor area remaining.
So it can't open the door for somebody in the future to come in and say, I bought a TDR with an expectation.
No,
Okay.
and again, I guess the other caveat to that, of course, is someone who has obtained an approval to use TDRs that exceeds 9250, they are vested. That
Okay,
approval
right.
is currently vested, so that is not affected.
Just want to make sure that was clear to the
But
public.
no, any future approval or use of
It's
TDRs.
9250.
Right, right.
And-
is
But
the
so
Francis-
it'll only really affect people with more than 2 TDRs right now, who won't be able to use all 4 TDRs if they've already purchased them. That's whom this will affect, correct, in terms of TDRs?
Right, I mean, so say a scenario, if you had gotten approval at one point to go up to 15,000 square feet using 4 TDRs, but you have never pursued that approval, it's no longer vested. This goes into effect. You will not be able to land 4 TDRs on your property to go up to 15,000 square feet. You would be limited to 9250.
But you can sell them. Yes.
I just wanted to say this, thank you for correcting my misperception about this, which I stated in a previous meeting and caused some concern. And just want to say, what you're saying today is how I understand it, and people should know that this was correct. That, you know, you've corrected the record, that I created some confusion, so I just want to make sure people understand that I recognize that also.
Yeah, and I think, right, I mean, what Greg had wanted to clarify with me was, in the past, if someone has not used all of their TDR, right, they've had the opportunity to come back in on their property. There is no ability to say, well, I didn't use that last 500 square feet, can I sell it to my neighbor? That doesn't exist. That it would be limited to use on their property, but as long as their property, you know, with the current zoning allowed for that, we have let people come back in and use the remainder of that TDR
And
on their
a
property.
succeeding owner could do the same.
Right,
Yeah.
right. It runs with the property.
Runs
With the
property.
caveat that it wouldn't, until it reached the maximum house size in effect
Right.
for that property.
Right. But essentially with this, we'd be saying, right, if you're over 9250, you hadn't used that last 500 square feet, but you'd extinguished the TDR already, and there was some remaining, you would have what the language says now is drafted, it would allow you to utilize that remainder.
In excess of 9,250 square
Correct.
feet.
Even though now we don't allow that.
Now,
Not quite. We're not quite there.
now, without the land use code
Yeah,
change,
prior
today,
to
again.
Yesterday, we don't allow that.
I just want to clarify, because I'm not sure today, we allow you to use what is left over, as long as, we wouldn't allow you to exceed 15,000 square
I
feet,
guess
if
what
that's
I'm
your
saying
remainder.
is, yesterday, we have some caveats that tomorrow we may not have.
That's what I see. too.
Exactly. With everything we did today.
I'm not sure I can not,
Can you put
if
that
you're,
in?
get there,
if
we'll
you're
get
clear,
there.
then that's great.
I get it.
Suzanne, you
because
just smile and say
yesterday-
yes.
Yesterday, you had to stop at 15,000 square feet, even if you had leftover TDR square footage. Now we're
Takes 30
saying
days to enact,
you
right.
can go over 9,250
It's not an
square feet
emergency
with your
ordinance.
extra TDR. And so that is a interesting discrepancy there.
Did we write that into that? I think we did.
Okay, so now,
Can't we?
we have some of the data, that you'd asked for. And speaking of caveats, we'll just say that staff has been running a bunch of numbers on growth management and TDRs to try and answer your questions, which were, right, how many would be affected by that? How many properties have growth management allotments that exceed 9250? Similar question with TDRs, how many would exceed? So this is our best effort based on the information we have and trying to correlate building permits. And so anyway, we've tried to distill it to this, but we're always going to say, this was not exact. We've made our best effort to provide numbers that we think, are as good as we can get you at this point without digging into every single individual property on all of the lists related to this. So this is our best effort at this point to give you some numbers. So to walk through this for the GMQS potential impact. So we looked at 85 allotments. So again, these are growth management allotments. Those are for new development rights as well as for additional floor area. we ran the numbers for allotments from 2001 through 2019, and that was because the regulation changed in 2020. Prior to 2020, the code always said allotments do not expire. Starting in 2020, we put a 5-year expiration on growth management allotments. And again, to the other point from there, 2020 to current, we're also looking at those approvals presumably being still vested. So we kind of took those out and looked at allotments granted through 2019. So out of those 85 allotments, we came up with 22 allotments that would exceed 9250 and hadn't utilized that the square footage allotment, so to go up to. And then that's broken down into, I haven't used my allotment at all, which is no square footage used, or I used a portion of my allotment, but maybe not the full thing. So that's partial square footage used. So of those 22, we came up with 9 allotments greater than 9250 that had not utilized any portion of that allotment, and 13 that had partially used their square footage allotment. Of those 13 that had partially used, again, as the language is proposed today, what we've assumed is if you've partially used, you came in for a permit, you had to demonstrate that you had met your growth management commitments. So we've, again, made that assumption that if you partially used, you'd met your commitments, and then that would mean that the land use code changes would not apply to those 13 properties. Of those 13, 12 of them would be otherwise impacted by the 9250 limit. One would otherwise have been affected by an overlay zone district restriction.
But they won't be affected because they've completed their commitments to the county.
Right, so the way the language is drafted, right, through a demonstration that you met those commitments, then the changes would not apply.
Is there a scenario where some who didn't use any of their square footage would have fulfilled their commitments at all?
Some people have, I think.
It's possible. I mean, again, if upfront, when a covenant, was recorded, you might have, say at that time made payments, if you had said, I'm going to, pay X amount of dollars to the fire district to support, something. I think most of the ones we're seeing in that have not used square footage at all are older. Again, we go back to, 2001 with these allotments. I don't know exactly when we started even requiring the recordation of a covenant, but only in very recent time, is that covenant getting recorded basically right on the heels of an approval. A lot of times it didn't even record, again, till you were coming forward to utilize the allotment. We were capturing the covenant that said, here are all the things I committed to do, so I'm doing them. So again, the way the language reads, there's language about demonstrating that you've met commitments. So again, even if you, weren't in that partial, even there, we're going to want people to walk through, we're going to want to document, I've met these commitments, here's how I can show that. So same if you hadn't used any at all.
And
That's so interesting. You'd go through growth management and not
do anything.
Yeah.
this is
Maybe
just
we made it too
GMQS.
easy.
Just square footage awarded through GMQS, not TDRs.
Correct. We have a separate piece for that. And Kelly, I think to your comment, when we first, back in 2000, changed the code, 50, that was when 5750 as your growth management exemption was created, and the whole idea of competing in growth management for additional floor area. I think we did see a lot of properties that came in and said, well, I want to get that back.
Sure.
So I think a lot of people went through the process at that time. It was a different process. There was no, you didn't have to have a full site plan even. It was pretty much, it was a more basic process to get that allotment. So I think that's a lot of those that we're seeing.
Okay, thank you.
Okay. Any more digesting on this one? Do you want to move on to the next?
Yeah.
Okay. Okay. TDR potential impact. So we worked off of a data set of 210 receiver sites, 1997 to 2023. And these include ones that are approved through special review, or TDRs were extinguished on sites where special review is not required. I think as you all know, but I'll walk back through it. Under the code, if you're in the urban growth boundary or you're in any of those subdivisions listed, Starwood, Owl Creek Ranch, Castle Creek Valley Ranch, those were areas where we said, these are areas where we're okay having TDRs land. We've, and we'll create that in the code by saying you do not have to go through special review to be an approved receiver site. So essentially they were approved receiver sites. And then they would just go through site plan review. But so the way those work is we're not capturing them until they walk in the door with a building permit, and they actually extinguish those TDRs at that time. We go, oh, okay, here's an urban growth boundary property. They didn't need an approval, but now they're landing on our list because they're extinguishing those TDRs. So those are included in that 210. Just to note, properties with vested rights are not excluded from this data set. Again, the data set's much bigger, and it was too much to try and sort out how can we figure out. But again, if someone has an approval to land TDRs for additional floor area and that approval is vested, they're not going to be subject to this change in the code. But just to know that these numbers, we weren't able to call those out at this point.
So that would make these numbers smaller. Yeah.
Right, yeah, exactly. So out of the 210, we came up with 67 receiver sites with approved or remaining square footage greater than 9250 or greater than an overlay zone district. Of those 67, again, so no square footage used would mean you have an approval to land TDRs, but you haven't acted on that approval. You haven't used the TDRs. So there were 18 of those, and there were 49 where there was partial use of a TDR. So you landed a TDR, but you may not have used all of it. So again, I think what's really important there to note is that in some cases, you may have used 2,300 square feet of that TDR, so there's 200 square feet remaining. You may have used, 400 square feet of that TDR for something specific you wanted, and there's more remaining. So there's a range there.
And some of them were vested.
And right.
Correct, yeah.
Okay.
So then further breaking down, I guess, of those 49, 44 of those would exceed the 9250 limit with the use of that, the remainder of that TDR. 5 would be affected, were within the overlay. So, and again, right now, the way the language is drafted, these would not be caught. The new language, the new code would not apply to these properties.
Steve has a question. Steve.
Yeah, Suzanne, if someone got approval to land a TDR, then they got a vested right, they maybe didn't even purchase a TDR yet to extinguish, would that TDR approvals be terminated if their vested right doesn't, if it expires and they haven't extended it?
Yes, once your vested right has expired, then the regulations will apply. So then you would be subject to the limit.
So some of these have vested rights, and I guess it would be the ones, the 18 that no square footage was used would be the ones that would apply to, is that right? They haven't used it yet, their vested right eventually expires, they lose the right to use the TDR at that point?
They could not exceed 9250 or the caucus limit at that point, yes.
They can use the TDR, but not.
Right,
not going over.
again, right, they might, again, like today, if you're going up to 15, there's a portion of that fourth TDR that you don't get to use. There may, that would be the scenario with, if you use one TDR to 8250, then you're using 1,000 square feet of a second TDR to go to 9250. But that other 1,500 square feet goes away.
Oh, okay, there, and I'm seeing that now there's a difference between those that would go over 9250. Some of the ones with TDRs only are going up to 8250 anyhow.
Right.
Yeah, okay, I understand that better now. Thank you.
Yeah, and just to understand, right, I mean, that's why a lot of receiver sites dropped out going from the 210 to the 67, because we were pulling out anything that was not, going above 9250 or in a specific, the overlay zone district areas was going above that limit.
Okay.
So, right.
And the Growth Management Advisory Committee did not make any recommendations on what to do with all these properties. Correct.
Right. Right. They were not having this conversation.
They didn't have the conversation at all?
About.
Kara?
Can you?
To Suzanne's point, they did not have this kind of conversation related to the TDRs. What they recommended is kind of re-envisioning the TDR program.
Mm-hmm.
To the best I could say, and Suzanne, this conversation, if those recommendations were implemented of the revised TDR program, this conversation wouldn't be happening.
Because
Period.
TDRs would have a different value.
And different, the way they're used,
Or
the way they're
something.
landed.
Different square footage.
It's just a
value.
very different program.
And it might occur because the change in value of square footage of a TDR might not be retroactive. We don't know.
So, right, there's a whole
Yes.
other
okay.
conversation on
Okay.
this topic
understand.
that will happen with, when we look to implement the growth committee's recommendations.
Yeah, okay.
Okay. Any other questions on the TDR piece?
Thank you for the information.
Okay, I think,
Just, I didn't think the
Okay.
numbers were gonna be that high.
So, we didn't fix that slide. It's on second reading. We're recommending that the board approve the 6 ordinances. I'm not going to read all that language. If it has to be done at some point, I'm happy to do it for you. But again, it's the text amendment ordinance, as well as then the subsequent rezoning ordinances for the overlay zone districts, and the 9250 overlay countywide final maximum floor area. And I guess I would just note that all of these ordinances include language saying that they would be effective upon adoption.
Yeah, okay. So this vote that we're about to take does not adopt these changes. This is not the vote that adopts them, but it is the vote that changes the text. Then we adopt it.
This would be, if you vote today to approve on second reading, that would adopt, again, 6 different times, adopt all of these changes, and they would be in effect immediately.
So then why do we bother with 12?
With
8,
12.
9, 10, 11, and 12? If we
Each
vote,
one has a separate ordinance.
yeah, but I thought you had said that when we vote on 7, we're voting on text amendments and approving the text amendments. But then we adopt those text amendments in 8, 9, 10, 11, and 12, I thought, something like that. Could
So
you explain again the difference then?
Yep, you bet. The first one, number 7, is the text amendments. They will amend the language in the land use
Right.
code. Number 8, sorry. 9, 10, 11, 12, 13 are separate rezoning ordinances that also have to be approved on second reading, and all would also be in effect immediately.
Okay,
That's how the process works.
yeah.
Think of it as
So,
like a map, like the 8 through 12 is adopting
This
the
maybe
map.
mentioned
Yeah.
is different than theirs.
That the
okay,
code changes
so I
effect.
think what we have to decide is whether we want to make all those exemptions, whether we're okay with all the exemptions. That's where
I'd like to-
that's where we left off the conversation last time, and we asked Suzanne not to change that language, but to bring it forward,
I'd like to hear public
allowing
comment.
all those exemptions, and now here we are. What?
Can we hear public comment and then discuss?
You want to hear public comment
Oh, yeah.
before we discuss that?
Please.
Okay, we were going to hear public comment at 12. You want to?
And I also want to note that Suzanne sent us on 3 letters, 3? That were
There were
received.
4 letters.
letters.
One, I think, referenced the other
And
letters.
then we got
so-
one also directly today, so we've had a lot of public comment that came in from Judd Clarence, the local realtor.
Okay, didn't see that.
Oh, here's a
I'm fine with
copy.
doing public comment. but we had a discussion.
I'll make sure it gets in the public record.
Great.
Suzanne suggested at 12.
I guess, I
I
think,
think we're done.
But we can have public comment now. I'm fine with that. Okay. I'll open the public hearing.
Is there more presentation?
Is- Do you have more presentation?
no, I'm done.
We don't need it.
Okay. So, can you just give me an idea? If you're wanting to speak, raise your hand so I can get an idea of what we got going here. I'm seeing 4, 5, and online I see 1. Okay. Let's just do the online person first.
Good idea.
Hi, can you hear me?
Yes, we can.
Yeah, I do want just like a little bit more clarification on timing.
His name.
A little confused on how these proposed ordinance, the proposed ordinance language works in terms of
His name.
some inconsistencies that could arise where you have pending applications that have been approved and accepted, but then need to go out and get a TDR before they get their building permit, if I have that right. I'm just confused on how that really works, where you could have an approved land use application, but then still need to go out and get a TDR before getting your building permit.
You can
And then you're kind of in limbo now where you fall into 2 categories for the new ordinances.
Can we verify his name on the record?
Yeah, can we have your name, please?
Yeah, Alex Lewis.
Thank you.
Thank you. Okay, go ahead and answer that, Suzanne.
Okay, Francie. So, right, when you get approval to land a TDR, we do not require that you own the TDR at that time. The actual TDR is just required to be submitted and extinguished at building permit. So if you have gotten approval to use a TDR, you have submitted, you're still vested, then this would not apply. You'd still have to go out and buy a TDR, but the new legislation would not affect that approval as long as it's still vested. If someone has submitted for building permit based on their approval, that will still move through the process. If it's for a 11,000 square foot house, they have approval to use the TDRs. The TDRs will be required to be extinguished in that building permit process. Again, so there, I guess maybe the issue that you don't understand is you don't have to own the TDR at the time you get the approval to use a TDR.
As long as you're vested.
Right, so you get a vested right as soon as you have approval to go out and get your TDR, and you can get a new TDR, or if you have a partial TDR, you could also use that.
There is no
Partially unutilized TDR.
On that same property.
So again, the only, there is no partial TDR to buy on the market. In the cases we're talking about partial square footage remaining from a TDR, someone has actually extinguished the TDR with a building permit, but may not have used the entirety of the 2,500 square feet available from that TDR. So if they had some remaining, right now the ordinance reads that they would still be able to use that remainder.
Got it. Okay, yeah, that makes sense. I just wanted to clarify that that time between approval and actually getting the building permit on whether or not TDRs can then be obtained. So thank you, I appreciate it.
All right, thank you. Okay, in the back on the right side, my right side, your left side.
Peter. You know Peter? He's on the APSHA board. What? Peter's on the APSHA board now. We met him.
Hello, Peter Grenny. This has been a interesting hearing to listen to and try and track and follow. It seems like there's a lot at play. And I appreciate that the Growth Committee met for 10 months working on this, bringing forward a recommendation. But this is so complicated. It's just been difficult to follow even this meeting and all the different scenarios that have come up. And in light of the fact that the public hearings have been in October and November, I really wonder how informed the public is about these changes that you're considering approving today. And I just want to, seeing that there are only 3 public comments on this, I want to reiterate or add weight to the 2 that came from Growth Committee members. So one, the first one says, many of us did anticipate that the process would take some time to come to fruition. Thus, in our report, we did try to think of which items might be best for early implementation. And the ones they list are building code, performance, water conservation. So it doesn't even seem like the Growth Committee was anticipating that the max home size would be the first one that came up. The other letter speaks to that same point and just says the square footage cap was the most divisive and exhausted topic discussed by the committee. To adopt the most controversial element of the committee outside of the context of other recommendations does not feel equitable. So it's alarming that members of the committee feel this way after they're the most informed and have worked on this the most. And then another point that stood out to me, it just says, even with our extended 10-month time frame, we realize that our plan needs to be analyzed further by experts who can confirm our theories are merited. So it seems like in those recommendations, there's a lot of theories that haven't been vetted, and I think the community deserves, with something with this magnitude, that all those theories be vetted by experts, and that we're really going to achieve the goals of this ordinance.
Thank you, Peter.
So can I just ask a question? Did we hear anything different from Michael Miracle or Mona, who are the chair and vice chair of the committee, right?
Recently about this?
When they came to they were part of the first reading, I believe. Wasn't Michael here and Mona came in online?
We did not hear anything different from them.
I didn't hear that this was a concern. I think what we heard was they appreciate the fact we were moving forward. Okay, just want to clarify that.
And over here, yeah, hi.
Hello. My name is William Modi with Roland Broughton Architecture, and we have clients that fall into the category of the TDR with square footage that has been exhausted on their property, and wanted to kind of just reiterate that when they purchased these TDRs and landed them on this property as part of a previous building application, they were doing this in good faith. And, you know, it seems, I've been talking about this with colleagues around the industry, and it seems like the existing nonconformity provision of the code might be able to be utilized in this scenario where this square footage was landed under, you know, if it gets approved today, what would be a previous version of the land use code, and then be able to ride with that property. So has that been a consideration, especially in light of the comments about potentially rewriting the existing nonconformity section of the code that was brought up today?
We haven't had the discussion sort of in more to that detail of taking them out based on a nonconformity. Again, we were just looking at it as the applicability up front, the way the language reads, whether, you know, again, if there was remaining floor area out of a TDR, if that would still be allowed to move forward based on these regulations not applying in that scenario, rather than kind of going down the non-conforming road.
Got it. So then, with each of these properties where that was landed, how would that square footage be kind of tracked? through that process?
We'd be going back into the building permit file, where essentially we have the receipt of the TDR being extinguished, and basically that building permit to determine, how much of that floor area was utilized and what remained. So again, it's definitely on a case-by-case basis to kind of walk through that analysis. But basically the numbers are all in that building permit. Where did the floor area end up? They were approved for how much, how much could they have used out of that? They landed the TDR, what remains.
Right. Okay. Thank you very much.
It's nice to see you. I'll let Trevor know.
What? Are you just talking to him?
Yeah.
There's somebody else in the back there? Yeah, go ahead.
Hey, Lex. Good afternoon. Lex Terumians. My major concern with this is not so much the house maximum size being downzoned. I think it's the way it's been handled over the summer after the committee's recommendations. I have a specific client who submitted for pre-application in May, towards the latter half of May, was not granted a meeting until October. And these are complicated applications that have to be put together. He's going to miss the deadline. If this is implemented today, he's going to miss the deadline. He's a 50-year local. And I think that it's too fast. I'm here to ask you to consider a 30 to 60-day extension prior to enacting the smaller home size. There are 8 TDRs on the market right now, county TDRs. If there was a true rush for permits, I think, and for people trying to get in under the wire, I would assume that those TDRs would be gone at this point. And I think that, and I've seen this in the city of Aspen when the city eliminated penthouse development in the central core, and then they eliminated it from the mixed-use zone district. There's no doubt during COVID we were in a period of time where it was unprecedented, and we were seeing a lot of things happening in our community that we maybe did not like or did not want to see. This is all calmed down at this point. I don't know what the data is, but I don't think there are that many people that are racing out to build 15,000 square foot homes right now in this county, especially with where inflation and construction costs are, where the cost of TDRs have gone, where the cost of land is. So I think from providing an opportunity for longtime landowners that have been in this county for a long time, have held property, they're the ones that are going to be most impacted by this. The extremely wealthy person that can only have a 9,250 square foot home now versus 15,000 foot home, they'll have 2 homes if they want. But we have people that have been part of the community that have been working to get through this process and are going to fall short of having their applications in if this is enacted today. So, thank you.
Thank you.
Thanks, Lex.
Thanks. I forgot about the timer. Thank you.
Hi, good afternoon. Chris Benden with Benden Adams, here representing several clients, as you probably know. 3 things to say. First, I appreciate the exclusion language in the ordinance that you have that makes clear that applications, land use applications that have been submitted and accepted in will be handled as a pipeline project that's consistent with how the county has handled this in the past. and reduces anxiety levels across the board to see that language, and so appreciate that. Second is just want to acknowledge staff in this situation. You know, I've been in their position quite literally, where there's you know, a lot of things going on and codes changing and so on, and it's not the easiest sort of environment to work in, and they've been highly responsive and continue to do their job with diligence, and just thought I should recognize that because it's not always recognized in this circumstance. And then last point is with respect to the potential for partial TDRs. I don't know how to phrase it, but either partial TDRs coming back off of a property. Right now, the TDRs are worth 2,500 square feet. It's not the most convenient increment in your, and I know you're not there yet, but considering breaking them into 500 square foot increments is, I think, is a good idea. There's just a little bit more flexibility there. You know, in the past, we've had clients sort of just have to come to grips with, you know, you land a TDR, you just can't use all the square footage for whatever reason, and there's just no change back. And you know, that's I would like to see the county pursue the opportunity for those either smaller increments of TDRs to come back off of the property, or a partial TDR or what have you, so that we can deal with those kind of smaller increments. And I know that's not necessarily what you're dealing with today, but I think that's something that would be wise to pursue.
Thanks. Thanks, Chris.
Interesting.
Yep.
Thank
Thank
you.
you.
Thanks, Chris.
Who else? Sure.
Oh. Decided to come see us in person, huh?
Yeah, every once in a while. The good news, I'll be very brief.
Don't forget
As
to tell the
Suzanne has
public.
described this,
Don't forget to tell the public who you are.
Joe Wells, my wife and I are on the list of 13, so we've partially used our allocation, and we've entered into an agreement with the county to not exceed the maximum allocated square footage. So I don't need to take your time as long as you agree with Suzanne. So we'll see how that goes.
Always agree with Suzanne, don't we, Suzanne?
Thanks, Joe.
Thanks, Joe. Nice to see you.
Glenn.
My name is Glenn Horn, and I just want to say I support the ordinance as drafted with respect to the floor area limitation as well as the exceptions that are in there for vested property rights and also for applications that are deemed complete. And I just want to say we're thankful to the staff for working with us to process an application that just in the past couple of months that would exceed the 9250, and they were very helpful and dealt with it in a timely manner so that we could get in before the legislation was adopted, and we thank the staff for that.
Thanks,
Glenn. Anybody else?
There's two.
Yeah,
and then
come on up.
Gideon.
I'm Cliff Weiss. I was a member of that 10-month advisory board. First, I wanted to say thank you to the board, BOCC, for prohibiting STRs in the backcountry. It's a big pet peeve of mine while on your P&Z for 6 years. That was terribly frustrating. So thank you. That was kind of a monkey getting off my back. I came here because I missed your first reading. I was on vacation and out of town. And I was kind of confused by how we struggled, as you've kind of heard, for months trying to find consensus as to what the house cap should be. What we finally agreed on, 8750 for everywhere but the UGBs. And I don't understand how it has moved back to 9250, which was only in the UGB. I want you all to be a little bolder and take the lower number, which had the consensus of the advisory board. Just my opinion, but I came here and listened to this for an hour and a half to make this point, not to mention the 10 months on the board. The last thing I wanted to bring up, although you're not dealing with it today, is the residential TDR program. I was probably the sole no vote, and I wanted you to hear now why I did not vote for it. I happen to think the program's terrific, but I was concerned that it would cannibalize the rural and remote TDR program. And so, and the advisory board had heard this from me many times, but in the end, they voted for it without ever coming back to me with, here's how we're going to protect rural and remote TDRs. So I just want to bring that to your attention so that exactly, as I said about STRs, TDRs in the backcountry, very important. Okay?
Thank you, thanks.
There is an explanation for the 9250. I would like Suzanne to take a second to tell you that, if that's all right with everybody else.
Yes.
Let's see. I have to walk back a few months to.
Or John, right? Yeah.
Yeah, no, sorry. Thanks. Okay, that gave me a chance to get my thoughts together. I think staff had actually initially proposed it at 8750. Before we went to the P&Z, we did meet with a portion of the members of the growth committee to have that discussion with them. There was some support at that time. There were definitely concerns raised after that, again, once people had more time to think about it. One idea that surfaced out of that was taking the higher of the two numbers for this action now, knowing that we're going to do a much deeper dive into all of this as we work on the entirety of the growth committee recommendations. So again, I think it was sort of a compromise, at least on, on the front end now. And I don't know if John has any more flavor to add.
No, I think you've done a really good job explaining it. I mean, at the end of the day, and Cliff, you know this as well as anyone, right, that this was a hard-fought compromise to get to the committee's recommendations, and it really incorporates the full scope of mitigation measures as well as square footage. And this was just in a lot of follow-up conversations, a number that again, I think reflected another hard-fought compromise that we were able to at least get some agreement on through the preponderance of growth committee member comments, I would say, after our meeting that we had, as well as with the Planning Commission. The idea here, though, is that we pursue the full suite, and we've taken direction from the board to pursue the full set of recommendations of the growth committee, and we've we've gone through a bid process, and I believe entered into a contract at this point for that purpose, and so I'll be moving forward to really get to the full set of recommendations. So. It is often a messy process. This one has been. The interim steps allow us to do something now that starts to move in the direction of changes that were recommended by the board, while we deal with much more complicated code and performance standard issues that are going to take a lot of time.
And I thought part of it had to do with setting up two different zone overlays, one for 8250, one for 8750, one for 9250, and we really wanted to get something moving in response to some pressure from some of you guys to get it going. So That was my understanding.
Yeah.
I understood the combination of the two and to make it county-wide, other than the overlay neighborhoods. And I think just even if you look at the overlay neighborhoods, they're willing to accept as much as 5750.
Yeah.
There are a lot of people on the board that started there.
Yeah.
And there are a lot of people that really didn't want to see any kind of house cap reduction.
Yeah.
So for us to come to 8750, I'm still not hearing an explanation for why 9250, which would have been 5% of the land mass of the county, versus the 8750, the other 95%. That's all I'm here to advocate is reconsider that, but
It'll be back.
It'll be back. It will be back. And thank you very much for your time on the
Yeah,
committee.
thanks, Cliff. That was a great group.
Thanks, Cliff.
And Glenn, too. Well, we got
We
Gideon over
we
here
have
in
been
the
thinking
corner.
about that.
For the record, Gideon Kaufman, and I spoke at the first reading, and I want to reiterate what Glenn said. I'm supportive of the changes that were implemented, and just ask, I'm not going to take your time to speak now, but if in the board deliberation you decide to make some changes, I would hope that you would reopen the public hearing so we could comment on those, and I'll stop there. Thank you very much.
Thanks, Gideon.
So again, I want it on the record that Gideon Kaufman is agreeing with something we're bringing forward on land use.
Yeah, I know, I'm noticing.
I would qualify it with so far.
Yeah, so far.
Are there other people out there who would like to come up? No? Anybody online? Anybody come on recently? All right, I'm going to close the public hearing. I would like to say, in response to some of the letters that we got that said there, and one of the speakers today, that there hasn't been enough time for public comment or public interaction. All of the committee meetings were open and available for people. And so that was a lot of time. That was 21 meetings where voices could have been expressed. And I hope that people will stay engaged, because we're not done after today. We'll be going forward, and I hope the public will remain engaged. And I really appreciated some of the things we heard, and I wanted to bring up one thing in response to them, if you guys don't mind if I go first. And that was the suggestion that we do a 60-day period. I just would like to put that out there for us to
Extension?
talk about a little bit. I
Until
thought it
we
was an
enact, you
interesting
mean?
suggestion, yeah. Does anybody want to comment on that? Steve, did you want to comment on that or open up something new?
Well, no, it was your previous comment.
Oh, go ahead then.
If there have been public hearings during the course of the summer at the Planning and Zoning Board who were looking at this 9250 number and the overlay, zoning overlay districts. So there has been plenty of opportunity for the public to comment. Also, at our first reading, we took public comment at that. So those who say there's been not enough opportunity, I think they maybe weren't paying attention, but there has been really lots of opportunity for the public to weigh in on this.
Thanks, Steve.
As for the 60 days, I'm good with enacting it now.
And it would take effect in 2 weeks, is that?
Immediately upon
Immediately.
adoption.
Immediately.
I understand that, and maybe that's something with that application that got hung up. Maybe there's some discussion that can be had with staff. I don't know the specifics, but we didn't hear from anybody else who was caught up in that, except for one, and maybe there's some issues there that we aren't aware of, but I'm comfortable moving it forward. And it's not because I think people are gonna want to rush in at the last minute. It's because I think we need to get it moving.
Okay. Anybody else? Yeah, Kelly?
I'll have to mull over that a little bit. I'm not super inclined. I'd like to be clearer on where our agreement is on what we're enacting. And then think through more about
The
the
timeframe.
timing of that.
Did you have some questions then about that?
Well, I do want to hone in on sort of the last exemption, which I feel like is where our conversation at the first reading really
Could you pull that back?
held. So looking at the two slides again for GMQS and TDR, my inclination is to not create exemptions that we don't currently have in our code. So allowing someone to use over 92, we don't let people use over 15,000 regardless of their extra square footage. I haven't sort of been convinced why we should do that for 9250. Is the detail that I think stands out to me a bit on this. There's the way that I look at a TDR is, a TDR is like a thing required to build your project, and the square footage value that applies to that based on your project. We don't have a TDR program that is parsing up square footage in a way that we're contemplating for the future. So, I think you need it for your project. You got it for your project. If there's square footage that you can use and remain within the code, I'm totally fine with that. I'm just struggling to say like additional square footage should allow you to build beyond what we're adopting here today.
For those that aren't vested.
Right. Yeah, I'm totally fine with all the approvals, all the vesting, all that is I'm totally fine with all that. I think that is the right thing to do. Yeah.
Well, right now it says that if you are vested, if you're in the process, et cetera, and you got your TDR, or you have the right to use a TDR, it doesn't mean with the 15,000, there was no discussion about, if you bought 3 TDRs and now we're saying 15,000, this is if you're already kind of in the process and you have this remainder amount. So I think it's very specific. It's not as broad as before. Does that make any sense? There's a difference to me from the 15,000 to what we're doing here today with the use of TDRs. And it's very specific as to who can exceed and who can't and why.
Yeah, if you have leftover square footage on a TDR that you needed for a project in 2015, I don't think you should get to use it in 2025 to go above 9250. I think you can use what you have up to 9250. Like if this, if you haven't, for something that you may want to do that doesn't have approval, doesn't have any vesting, I'm not compelled to say, yeah, you can use all of your extra square footage above and beyond 9250.
I can understand that, but for me, it's changing rules in the middle of the game.
Why though? But I'm talking about someone who has a TDR that they needed it for that project they did in say 2015, right, and maybe had no vision of ever using it again. They sell the property. The next person comes on and says, "Oh, I bought this extra 1,000 square feet along with this current 8,000 square foot house or whatever." Now they want to do their update to their property. Right. I don't see why.
What if
we would allow that?
What about the current owner? What if the current owner who decides now I've got 5 grandchildren and I want to add an extra bathroom or something?
Then add it up to 9250 because that's our code. Okay. Same way as we do now. You can add it up to 15,000 square foot because that's our code.
I think in this case and what we're doing now, it's we have a game going on and we're saying, you 2 strikes and you're out, not 3.
I'm trying to retain alliance with what we do now.
Right, I understand that.
Steve, would you want to jump in here and help us out?
Yes. When the people bought their TDRs and landed them, TDRs, and landed them on their property, I guess it would be TDRs plural if we're talking about going over 9250. They were doing so at a time when they could build a 15,000 square foot house. So they, in effect, by doing the land, getting their land use plan approved and landing a TDR, they were entering a contract with the county that they would be allowed to build up to 2,500 square feet per TDR that they landed.
No, they weren't.
There was no talk about 9250 at that time. The number was 15,000 maximum in the county. Now at this point, they have a property right which includes what they built plus some square footage that was not used, but they had the ability to use it prior to any of these changes we're talking about, up to 15,000 square feet. Nobody could go over 15,000 square feet legally. I think I've heard some stories of some people who did it surreptitiously, but that's beside the
Really,
point.
not here.
So we would be going against the contract those people entered. And to me, it's a private property right. We would be doing a takings if we took away 500 square feet from them or whatever potential to build at this point. That's why I would support allowing those. It's not all that many properties that have leftover square footage that they didn't use. I know of one property on Snowmass Creek who actually purchased a TDR from my family, and they expanded their house a little bit. They had permission to go up to 8,250, and they actually only built about 6,700 or 6,800 square feet of house and outbuildings. They included all their outbuildings in their 82, their calculation of their square footage. They didn't reach 8,250, but they still would have had the right to build add more onto their house if they wanted to, up to the full 2,500 of the TDR. The TDR has property value, and we cannot just ignore that. So I support allowing people, even if they go a little bit over the 9,250, and using what they entered in they purchased it in good faith, they got the permission in good faith from the county, and we need to honor that now. Thank you.
Kelly?
So if it's okay, Steve, I would like to challenge your argument a little bit. The contract entered into with the county was for the specific land use approval. The TDR was not a contract entered into with the county. That was something they bought on a market outside of the county, and they needed it for a purpose. And what I'm saying is, if you want us to honor the 2,500 square feet for anyone below 15,000 square feet, but not for anyone above 15,000 square feet. And I don't think that's equitable either. I think the equitable approach is that the TDR was used for the project that it needed to be used for. Now, if there's remaining square footage that meets our code, they retain that right. For any square footage that violates the code, just as we do above 15,000 square feet, that remainder square footage isn't applicable.
I think we have to agree to disagree at this point, Kelly. The people sort of had two contracts with the county. One, they landed a TDR, which gave them the ability to build up to 2,500 square feet more. Then they had a second contract, which was their building permit, which was their specific project at that time, which maybe didn't use the full 2,500 square feet. So they sort of had two contracts with the county of using the example of having this be a contract.
I think one of the things that's happened in the last 5 years, and some of these might have been purchased before that, is that we've recognized that we have a pretty serious environmental emergency going on. And we have quite a bit of science to show us that anything above 8,500 square feet raises its impact on GHGs and other forms of environmental havoc at an exponential rate. So I think that we need to keep that in mind when we think about why are we doing this in the first place. It's not just because some of us take offense at really big houses and whatever. It's really about responding to our climate action plan and trying to be responsible stewards of our county. And so I do think that part of what drove us in this direction in the first place was the information brought to us by Cindy and later Suzanne and others that showed us exactly what the impacts are of really large houses. And so I just want us to keep that in mind as we work our ways through the throes of these minutiae in the world of problems. So, you know, I don't want to negatively impact somebody, but I do feel that if we, not counting the vested ones and those things, but if somebody's built out their project and they no longer have a current building permit for further construction, and they might have some remaining square footage, I think I agree with Kelly that their limit is 9250.
Is that part of the exemption? If they're already done, their vested rights are gone, they still get this exemption? Just to
They
clarify.
have leftover TDR.
Right, the way this provision is written now, so again, if they're not vested, but they had remaining floor area,
Regardless.
right,
Okay.
that the way
So-
it reads now is they would be able to use that and exceed the cap.
And planning and zoning was okay with the language as written? The exemptions?
No, P and Z was,
yeah.
supported this, yes, the language,
Yeah.
this kind of.
So that's something we need to take into consideration, and the fact, this will be, I'll be coming back to us when we have the whole picture coming before us. So we have time to vet this between now and then, and the reason Francie was absolutely right, we went from 8750 in rural and 9250 in urban, which was presented, we decided to go 9250 across the board. At this time, knowing this was just a way to get us moving forward because of other concerns we had expressed. So that's why I'm comfortable doing it as written, moving it back, because I know it'll be coming back to us and we can, there's gonna be a lot more discussion.
Do you have any comments you'd like to make?
Yeah, I just want to say again that I appreciate Cliff's comments because I was asking the same questions he was. You know, it seemed like that was one recommendation we didn't go with, and the answer still doesn't sit well, only that maybe for the sake of moving it along, we have to do it this way, and then we're going to revisit it. It seems to me, and maybe Rye could help me with this, or Suzanne, that anytime the commissioners, at their discretion, change a rule, it's affecting someone, and some people will feel that it's unfair, others won't, that it'll affect the financial nexus and their plans and what they thought their property was worth. I think when we make a change, those things happen. And so I don't think it's out of the ordinary. You know, if you downzone the entire county, you're changing people's, calculations on what they think their property's worth or will be worth. And so I think that's what we're here to do, and we're here. I'm trying to, and I appreciate the comments from Steve, and I appreciate everyone else's comments. I've been listening, but I think I'm, if we're going to commit to 250, that's what we have to do. And so I was going to suggest that we approve this as presented to us today. Kelly's pointed out that we wouldn't want to include this provision.
I don't want to.
Sorry?
Oh, I
Did I
don't
get you-
want to, I don't know.
You suggested that you like as submitted, presented to us by staff, except for this part. And I am inclined to agree. And it's a tough one. I'm still wrestling with it, and we might need to change it. But I think today I would vote to move it forward, and I'd vote to keep keep this in.
So you would allow people to build over 9250?
No, sorry.
You'd take this out?
I would take this out.
These are the exemptions.
This is the not applies exemption,
Yeah.
yes.
Did you have something you wanted Ryan to respond to?
No. He doesn't, he's shaking his head.
Okay, all
Steve
right,
wants to
Steve.
respond.
Yes, I think that when we were talking, when we were advised to do the 9250 right now and exceed the 8750 figure, didn't it have something to do with House Bill 1255 and the implications of that? And that's why we were doing one figure only and not two different square footages in our
Yes, I think you're
action
right,
at this
Steve.
time.
I don't remember that.
I
I
think that's
believe
right.
that was part of the discussion.
Yeah, that it was discretion, it was discriminating against people, something like that. I remember that too.
I don't think it is House Bill 1255. I do think there was some desire to get initial recommendations of the committee codified as the landscape around housing at land use at the state was changing. But I think it was more, quite frankly, getting through a hard-fought compromise to get to where we are today, to be perfectly honest.
I don't remember it being presented to us that way. It might be how you guys proceeded with it, and I get that. But I thought there was something about discrimination. I know that the Down Valley representatives on the committee did not want to have the more rural parts of the area have less square footage allotted to them than the urban growth boundary. But because they made investments in property too that they wanted to protect. I do remember hearing that, but actually those people were in favor of the lower one, so overall, so.
Or no, none at all.
No, none at all.
Francie?
Yeah.
I just want to remind us that Gideon's last words as he left the microphone were, if you're going to change it as presented, he'd like public comment. And I don't know if you're going to offer that or not, but I just wanted to bring it back.
I'm happy to
Sorry to
open
open
it up
that
for a
can of
public
worms.
hearing again on this issue.
Just on this.
Just on this issue, yeah, which is D on here. Yeah, Gideon?
And I'm not sure where the vote's going, because I'm not sure where one member might be going or not going. It's not me.
Reading the tea leaves, I figure I should say something. And that is that, one point I want to make is that we're talking about, well, if you have a TDR today, you can't exceed 15,000 square feet, okay? But when 15,000 square feet was adopted, if you were in the queue or you had a vested right, you could go above 15,000 square feet. So I think we got to talk apples and apples. In other words, back then, if you had it, you went a little above 15,000 square feet. It didn't apply to. So we're talking about a new threshold. So I don't think we want to compare the 9250 to the 15,000. The other thing is, along with Steve said, and that is, if you get a land use approval, and in that land use approval, it's for extra square footage, okay? And the commitment says, well, the approval recognizes that you're going to go out and buy a TDR in recognition of the approval you got. So if you have an approval and it called for a TDR and you bought the TDR and you only used half of the TDR, it seems to me that there was some reliance on that action. So I would urge you to adopt it as it is. If you want to go back and, as Patty talked about, discuss it later on. But I do think, in fairness, if you have a land use approval and you use that land use approval, you bought your TDR in reliance, and then you only used half of it, why penalize someone who didn't run out and build all of it at once, saved the time when you had the grandkids or something like that? So I would urge you to keep it as it is. Thank you for
I
giving
hear
me the
your point.
opportunity to talk.
Thank you.
Could we ask Roy or Suzanne for clarification? Because it sounded like what Gideon just said, it was different than the understanding about additional footage above 15,000 with the TDR. If they had it, they could build it back in the day. What's your
I
recollection?
would just say it was, I think Gideon's point of it's hard to compare, it was a very different day. At that point that we didn't have 5750 and using TDRs to go up to 15. Once upon a time we had a review to go over 15, and at one point we threw in you have to get a TDR to do that. But again, it's definitely like apples and oranges in terms of this idea of I have a TDR, I used 1,500 square feet of it, and there's 1,000 square feet left. That wasn't the game was different. You know, it was a very different game at that point about going over 15. I think more sort of to Kelly's point, to clarify, I mean, when people got the approval to land 4 TDRs and wanted to, they knew 15,000, they couldn't exceed 15,000. They knew they were going to walk away from some square footage from that last TDR. You know, they knew that up front. You know, so that I think is more a comparison rather than getting into somebody who might have been able to go beyond 15 at the time versus now. Again, the difference is today we're talking about something remaining out of a TDR that you did purchase and land on your property. So.
Okay.
I would also add, Greg, that I think that, well, I don't think, the code is really clear that there's no vested property right in utilizing a TDR or the full amount of your TDR on the property. I think the 15,000 square foot example is a little more, I think it's a little more apropos to use something like a floor area ratio where you have a set limit for a property of, let's say, 7,500 square feet, and you want to develop up to that amount. It doesn't, just going out and landing a TDR on that property does not entitle you to use all 2,500 square feet of that TDR in order to exceed the floor area ratio for that zone district.
Okay.
Okay.
Thank you. That's helpful.
Chris Pendon again. My comment is maybe more one of clarity. I'm not sure exactly what this sentence means. Listening to your conversation, there can be a circumstance where a TDR has been landed on a property. It was not fully used. They used 1,000 square feet of the 2,500. If they use that remaining 1,500 square feet, they would still be under 9,250. And I think this sentence allows them to do that. I'm not sure if it allows them to exceed 9,250, but listening to you, I'm not sure exactly what this sentence means, and it may be a case
I
where.
think it's, what it's doing is exempting you, so it doesn't say that. It's like Suzanne said, should I say this the other way around? So it's exempting you from conforming to the 9250. If you're in this circumstance, you're exempted from the 9250.
By allowing you to use the rest of your TDR.
It may be just one of those circumstances where a few extra words makes all the difference, right?
Yeah.
Thanks, Chris.
I have a question.
That's helped.
Yes.
So when we get to the full discussion of all the recommendations, there's going to be a lot of discussion about TDRs, about fractionalizing TDRs. Would then somebody who had, I'm going to really throw a ringer in here, would then somebody who was not exempted from this for whatever reason, had leftover, so they had 500 square feet, we did TDRs in fractional 500 square feet, could they then sell their 500 square feet off their property? That's a question that might come up, and I will bring it up when we have the full discussion.
And that's probably going to be
These
the
are
good time to
extinguished.
answer it, but thanks for the heads up. Yeah.
But these are extinguished TDRs, and you cannot sell them off your property to somewhere else. Is that correct, Suzanne?
Well, that's how it's written now.
The
Yeah,
way,
okay.
But that doesn't mean it might not be part of the
Okay, yeah,
discussion.
Okay.
So there's opportunity out there to see how, there's still a lot of discussion to be had.
and
Okay,
just to
do you want to
cla-
respond
and I'll
just to this issue? Go ahead,
I just
Suzanne.
just to clarify to Chris's point, I think, you know, yes, right, this was intended to apply to somebody who has remaining and would be over the 9250
Right,
limit.
exactly.
If you have remaining and you're still below 9250, we weren't, you know, right, that was
Yeah,
taken
we
out.
understood that,
of
but
the-
it
right.
would be clearer, I
Yeah,
guess, if it said
got it.
that, yeah.
We might want to put that in there.
Hi, Will Odie with Roland Brown Architecture again.
Your voice is so quiet, my ears are so bad.
Sorry about that.
You can yell at her all you want.
Actually, the
Perfect.
microwave does not.
All good.
The microphone doesn't help, you just have to amplify.
And then if you want to cook dinner, we use the microwave.
Absolutely. I just want to speak on behalf of a couple of our clients who, and this is to a point that you brought up, Kelly, when they went through their land use approval process, they actually were intending on utilizing more square footage at the point of the approval, and those additional buildings, whether they were outbuildings or whether it was another part of the house, was approved through the land use process. The TDRs were then landed on that property, extinguished, and then over the course of that project, for one reason or another, they decided to hold off on those future buildings. But in some cases, they have even roughed in the infrastructure at this point for utilities and things like that. And so, I would just ask that you guys consider, what would happen if there was a previous land use approval that was granted as part of this, the TDR was there and extinguished on the property for the intent of actually using that remaining square footage in good faith at the time when the TDR was purchased, in the context of this broader conversation.
Yeah, thank you.
Thank you.
I think we get that. Gideon made that point, made that point to us before. I think we understand that. It's whether it aligns with where we're going. I think we could take a 5-minute break right
We
now.
have
if you
public
guys don't
online,
mind.
wait, do we still have public online that?
Are there any more people online, Rosa?
Is he
Okay,
there?
Alex.
Sorry, Francie, I didn't.
Yeah, hi, Alex Lewis. So I kind of have a twofold comment, and it's kind of following up on what Steve mentioned earlier about like a takings. It's my understanding when a TDR gets extinguished on property, that it becomes a property interest and that it runs with the land. And so to then change the code to essentially take away from that, to take away that property interest, I guess I'm not seeing how that's not a taking by the government then, and what kind of constitutional issues that could potentially raise to then, I just don't want to see this process go through and then, somebody challenges it and then we're in limbo on whether or not, so that nobody really knows what's really going on with this until it gets resolved in like the court system or something like that. And then my second question is just following up on my very first question in terms of if this language right here, section D, does get removed, how that would impact people who do have existing TDRs on property that has been extinguished. But then if this section is removed, then you would lose that right to go above 9250. But if you've already have a approved application to go out, get out into a TDR, would you now then have to go and get a second TDR to make up for the extinguished TDR that you're now losing the right to?
No, no. No, if you have a permit that has been approved, it's been completed and approved, you can fulfill that with the existing TDR. You could buy another one if you want.
It doesn't
If you
mean you
need
can,
it, but
yeah.
no.
Even if it's above 9250.
Yes.
Right.
Yes.
If you have a vested approval that allows for you to build greater than 9250, and, right, maybe you have TDR remaining from, that you hadn't used up with a building permit, you would still have the ability to use that remainder as long as that approval was vested.
Yeah. So I would like to take a break now. I'm gonna close the public hearing, and I just have to get some fresh air and think about what everybody said. So we'll be back at 3, what do you think, guys? 5 or 10?
Doesn't matter.
I don't know how much time you need to get fresh air. Could be an hour, or it could
Okay,
be
we'll
2.
be back at 3:08, Andorra. Welcome back to the regular meeting of the Pickens County Board of Commissioners. This is Wednesday, November 15th, and we are talking about land use. Okay.
The meeting has started. Sorry.
Okay, who wants to talk?
Could, I would just like to reiterate what I think I understand from Rye and Suzanne regarding what the land use code says about the rights that come with the TDR. Maybe we'll start there, if you could articulate that for me.
And while you're doing that, you could talk about whether or not it would be considered a takings if they can't finish using that TDR.
Okay, well, I think the two questions are somewhat interrelated, and then I'll let Suzanne jump in a little bit too to tell you how functionally I'm going to call it leftover portion of a TDR has been handled in the past. So the land use code does not define or include the right to utilize all 2,500 square feet from a TDR as a vested property right, or a property right that you have an entitlement to rely on if you go out and purchase a TDR or you land it on your property. The only way that you obtain a vested interest, a vested property right to utilize all or a portion of that TDR is if you have a corresponding site-specific development plan for that amount of floor area. So if your site-specific development plan is 500 square feet short of utilizing the 2,500 square feet of any given TDR, then you are not vested in that full 2,500 square feet. The code's really clear about that. And to answer your question directly, no, I do not think it's a taking if you have utilized a portion of the TDR to develop up to a certain amount on your property. You have exercised reliance on that TDR up to the amount of floor area that you applied for, and I don't believe you have any additional reliance on, let's say, a remaining 500 square feet. And I think reasonable people can disagree about that, but in my opinion, I do not think that's a taking.
So then an extension of that question, Suzanne, would be if you came in and you got a building permit for, I don't know, 9,000 square feet, and you use 2 TDRs, so you have a little left over, and you build out that building permit. So now so you've used up that building permit that you already got. Now you want to come back in to get a building permit to use up the rest of your TDRs. Now we're under a different land use code. You wouldn't get that, right? That's the way it was when it was 15,000 square feet. If I'm just saying that you bought a TDR to build out to for your building permit. You got your building permit, you got it approved, it was vested, but you built it out. You got your CO and all of that. But you still have some more on your TDR, and you decide a few years later you want to use up the rest of that TDR, so you come back in. Currently, you don't get to go above 15,000, and now we're discussing whether or not you get to go above 9250. That's the situation that we're looking at, right?
Correct.
Okay. So there is no vested interest anymore in building out that property more.
So, right, I mean, again, we're not talking you're saying you had a vested approval, you applied for a building permit, you extinguished TDRs in association with that permit, but one of those TDRs still had square footage remaining on it. So, again, I mean, that's the question. Today, under the code, if, you had room to go, you weren't getting anywhere close to 15,000 square feet, you still had square footage remaining, you'd come back to us and say, what do I need to do to reuse this? It may be that you just need to come in for a building permit to do an addition onto your house to use the remainder of that TDR.
Up to the cap.
Up to the cap.
Okay.
So we're changing the size of the cap.
Changing the size of the cap, and if we go with this, we're changing the rule, as Kelly pointed out at the beginning of this conversation. we're changing the rule. Now we're trying to say, well, you can go over 9250 because you have $600,000 worth of TDR invested. So are we going to honor that purchase that you made, or are we going to stick with the code? Patty?
Yeah, I understand that. Thanks for the clarity. My question is, if I come in and I get a land use application approval for. Okay, so the question is, if I come in with a land use application and I get an approval for 12,000 square feet, and I decide to build less than that, and I have the TDRs, so then, but was my vesting based on my building permit? When I came in and only wanted to build 8,000 square feet, even though my application was for 12 that I got approval for? So we see that a lot. People come in, they change their minds. They don't build this big. What's vested? The 12,000 or what they built?
Well, again, the question is, are they still vested or not?
Well, but it say they still are vested under their first.
So they still are vested with a site plan that anticipated development of 12,000 square feet.
That's the
Landing
difference.
TDRs, they're still vested, so they may have done a permit now to build not all of that, but as long as that approval is still vested, so again, that's a 3-year vested right, they could come back in to permit the remainder of what was there. If that approval isn't vested anymore, then the scenario.
Is it
that's a
different? I totally
And
understand.
we have a few of those.
Yeah, that are vested for more than they actually built, that additional square footage may exceed 9250.
Steve?
I'm fine with that.
So that would be a little tweak to this.
There's a lot of tweaks.
So what Rai said, I think, is clear, and I'd be willing to accept that as the wording, that if someone has leftover square footage on their TDR and has a vested right from a previous land use approval, they can build up to the amount that was approved however the wording would be, they would be able to build up to their vested right, even if that exceeds 9250.
That's a compromise.
In the interest of these people who have this situation and getting this approved, is there a way that we can say that in this case, it must come before the board to be approved? What's the language for that? Special review. And then we could say, okay, well, they wanted to build 12,000, but they didn't have the money then, so they've been saving up all this time, and now they want to finish it out, and their grandchildren are coming to live with them, and so we decide, yes, we'll make an exception in this case. Is that a possibility? Kelly?
I feel like we have a process for extension of vested rights that would accommodate that. Right? I mean, we have a process in the land use code that allows consideration of the board to extend vested rights. And so the extension of that vested right could retain their exemption if we approved that. So I don't think we need to create a new
And
process.
that's based on case by
They
case.
would come through as an extension of vested rights
Okay.
and then would fall under the applicability of this.
So there would be an avenue for people who have
In-
exceptional
in
In
circumstances.
some circumstances, because if your vesting has expired, there's only a year that you can come back in and ask to reinstate that. After that, you couldn't come back in and ask for that extension or reinstatement
the
of
point of
vested
vested
rights.
rights.
Right.
So
You
again,
can extend
it's,
and you can
you have a window
what did
afterwards.
she call it?
Reinstate.
Reinstate. Extending
And-
is when you do it before your vesting is up. Reinstate is the year after your vested was up.
And again, just to clarify, the language about if you have a vested approval already exists, in the
Right,
language.
exactly. We
So
already make an
again, it's
exception
not
for
a
that.
change to
Yeah, we're
the
talking about
the
people-
TDR language. Again, if you're vested, that's taken care of.
Well, I would include D if we had language through which we could make a few exemptions for the people that are still out there with this situation. That's the way I would approve this with D at this point in the conversation. So that's a suggestion I have for.
I'm unclear.
Yeah, clarify that a little more.
Well, I mean, coming in to extend the length of your vested rights wouldn't work for most of these people, because if you could only do it for a year afterwards, a lot of these people are gonna be beyond that 1 year after the expiration of their vested rights, so it's not gonna help the people that I'd like to help. So we'd have to have another way for them to have a special review, if I'm understanding it correctly.
I'm unclear on who you're trying to help. Like, what circumstances are you unsatisfied with that A through D?
Well, it looked like there were like 44 people or something who had TDRs unfulfilled. And I
Where's
don't know
that
how many
chart?
of those were vested. We don't know.
Right,
if it's
we don't
44.
have that
We
number
don't
for
know.
you, how many.
So
dropped
anyway,
out.
there's some people out there, and I would just imagine there are some people who spent trying to remove my judgment of extreme wealth from this conversation.
So
They
there's
had made a
67.
serious investment in buying TDRs so that when their circumstances allowed for it, they could build a wing on where their kid who was 15 at the time is now 22 and is gonna come and live there and raise his family on the same property. I don't know, something like that. I don't know. I can't come up with something specific. I
That
just,
presumes that, like, zoning doesn't change over time.
yeah, I know.
You know, another thing to consider is when was the TDR purchased? If they paid 200,000 for it, would that change your calculus?
Well, that's what I'm trying to take out of the picture is,
That doesn't
How
come into
much
it. We
money?
don't manage how much
Well,
they
you're
cost
sa-
or don't
well,
cost.
she said it, if they spend all this money on it, well, what's,
Well, for
what's all
them,
this money?
200,000 might have been a heck of a lot of money.
Might have been.
I mean, basically, I don't want houses built over 9250. That's the bottom line. But
Okay.
we are already making quite a few exceptions, and there's just these few that are just weird. And I'm just wondering if we just cut them off at the knees, or we say, we'll look at it again on an individual basis.
But I think we're making distinctions between groups of people who should fairly rely on the code in place as they were interacting with it actively, and, the community that shouldn't rely on the fact that zoning doesn't change and regulations don't change. It's very different to me, because you can change rules of the game. It's not fair to do it in the middle of the game. So if you're not a participant at all, then, it becomes sort of a policy opinion as to whether those rules change or not. It doesn't become unfair unless you're actively involved in it.
That's what I'm talking about, the people who are actively involved in it.
Yeah,
That's
and we
exactly what I'm
created
talking
exemptions
about.
for those.
Yeah, except for you don't want to have this exemption. So that's the only one I'm talking about. So, yeah.
This one has been addressed specifically in the code, right, which is why I asked Rye to reiterate what provisions does this code have for vesting in TDRs?
And there is none.
And there is none.
Steve?
In fact, it's very
Sorry,
explicit.
I didn't mean to interrupt
Sorry,
you.
it's explicit in that there is none.
Yeah. Steve?
I have a thought, a possible solution. If someone has leftover square footage from a TDR that they purchased in good faith, they're not allowed to use it on their property. When we come to the point of fractional TDRs or the 500 square foot increments for a TDR, that those people would be allowed to sell their leftover increments, perhaps if they have 500 square feet or more, they could sell 500 square feet or two 500 square foot ones. So that would leave the value, they would still have value in those TDRs if they had enough to do a fractional thing. Maybe they only have a couple hundred square feet and maybe we don't want to allow that, but maybe we would allow it. If someone had 200 square feet left over, could they sell that to someone else when we get to that part of our code revision? That would mean their value of their TDR is still there. They just can't use it on their land above 9250. They could use it up to 9250, but not above. So what do you guys think about that idea?
Well, it's in the future. Yes.
Well, I was going to
Which I already
say, that's a
mentioned that
future
we-
discussion to be had later. I'm willing to propose that we pass this, striking this exemption. The double negatives get me. So
So you're saying that you would prefer to vote on this without D, and you feel the same way still, Kelly?
Yes.
And Patty, you feel like you'll pass it with D?
Yes, I would pass it with you because my concern, we also have an issue of, when it comes back to us in a future discussion, we're looking at 82, 87, 80, we're looking at
8750 and 9250.
So that's gonna be a whole nother hit, so. So I would like to pass it as is, move it forward, and keep all these issues at hand for our future discussions, which we will be having soon, because we have a consultant on board now.
And Steve, you would choose to pass it with D? Is that correct?
I would pass it the way it reads right now, but it sounds like Patty and I are outvoted on the
Well, that's
sentiments.
what I'm
We
trying
don't
to
know. We
figure
haven't
out
voted
before
yet.
we
We
do
don't
an
have a
official
motion.
vote. Just checking in here
Yeah.
before we do an official vote.
Would you like a motion, Madam Chair?
No, I actually don't want a motion right now because I'm hoping to avoid a 3-2 vote on this. I'm hoping we can.
Well, the other thing we can do is eliminate the TDR thing right now and then revisit it all, and maybe parts of it would be reinstated in our future discussion.
I'd rather do it the other way around, leave it in and talk about taking it out later.
So
Is that
you're,
enough to vote
so
it down?
just to be clear, Steve, you're suggesting that
Rather
we
go
pass
straight
this
to
without D, and then as our staff works on this, they look at what's happening and who has this situation, and if they come forward and say, wait a minute, look, what did you do to me? Look at this, whatever happens between now and then, and they take that into consideration, and then we look at it again in, I don't know, 6
First
months,
quarter.
a year?
in the near term.
That's your suggestion? I don't think it'll be the near term.
I'm using Suzanne's words.
How long before we see anything else from the growth committee come back to us for consideration, do you think?
6 months?
Been there already.
An actual code language?
As you're developing the code language and you come to us for guidance.
Realistically,
Kara wasn't in here when I asked.
Kara's head's turned.
I'm
I would,
wondering how long it might be before suggestions for further action on the growth committee come back to the board.
like, and I asked the question, actual code language versus, we'll be talking about how we're working to implement things, but I don't,
I think as we are planning right now, we anticipate coming back to the board in early 2024 with essentially all the data, what is the code, the whole changes. So until we do a little bit more of that work over the next 3 months, we won't really have a definite answer, but at that time, we'll probably clue you in better of our time frame. Is that a very vague answer for you?
So near term.
We're just trying to figure out about if we take out D right now, when would we be reconsidering it?
that near term is not addressing this type of specific
Exactly.
issue at all.
Yeah, I
That near
agree.
term is defining how the next year to 18 months
Yeah.
is spent to get to the end of the implementation of all of the recommendations.
okay.
So, right, there will not be that kind of detail in the near term.
I'm comfortable with
You're
that.
comfortable with where you are?
Yep,
With leaving D off?
striking that.
And I would prefer to leave D in and reconsider when we get further down the line and have more information as far as what we're gonna do with TDRs.
Steve?
So here's what I'm gonna suggest is we leave the language in but amend it to say that, and Suzanne said this is already covered, but the TDR has been extinguished, but the total floor area available through use of the TDR has not been utilized on the property, comma, the remaining square footage of the TDR can be used up to the vested right that exists.
Which
Well,
means
if it's vested, it already can. We don't need to add that language. Vested is already exempted.
Could we make it clear
I realize that, but that would then
Wants to further clarify.
clarify it when somebody's saying, what about my TDR? Then they come to this TDR section and it explains they can use it up to their pre-approved amount. Or they could build up to 9250 or the maximum, well, the caucus area ones are all 5750, so they don't need a TDR anyhow for the 5750.
So, I'm just wondering about putting a caveat onto this, Suzanne, that says, unless approved through special review by the BOCC, that we don't exempt this unless it's approved. So we change the language of this to make it not an exemption, but we would be willing to review them. I don't think there are gonna be that many, honestly.
I mean, I guess I would just say, I think the concern there is, what does that look like? What criteria are you using? Staff wouldn't have any criteria, So again, is it just fully discretionary at the BOCC?
So you're not recommending that?
I guess, yes, correct. I would not recommend without having some very specific criteria to be considered for those
We
circumstances.
could develop that language. We don't have to develop
could
that
develop
today.
it, yeah. We wouldn't have to do that today, we can do that.
If you wanted to adopt this today and have that provision read differently than it does right now, we would have to come up with that language today.
Or continue.
Well,
Or continue.
which I think would potentially be a substantial enough change to not,
Yeah,
to have to
not pass this.
re-public hearing on it. But
Striking it's
adding
easier.
special review criteria seems like a meaningful
Would we have to
change.
send it back to the P and Z if we have too substantial of changes?
Yep.
Yes.
If we strike it, would it have to go back to the P and Z?
Nope.
The original ordinance as drafted, I don't believe included this language in it.
Correct. The P&Z made recommendations on applicability provisions, but that was not part of their
It wasn't a part of the
specific resolution.
So this came from P and Z.
As a recommendation, as part of a recommendation.
The Planning and Zoning Commission approved the ordinances as drafted in their packet. They made a further suggestion that the BOCC consider this particular provision as well as the GMQS allotment provision. So when this ordinance came to you all on first reading, it did not include this language. After receiving further direction from this board, we drafted language to include items A and B in the ordinance that's in your packet today, and to leave out C and D for further consideration by
Right.
the BOCC.
Yeah, remember that. And here we are, at further consideration.
And it sounds like A, B, and C are, well, any motion to approve would need to, because A and B are already included in the ordinance that's in front of the board right now, would need to include an amendment to the ordinance that's in the packet right now to include either C or D or both of them, or none of them.
Is there a procedure in place for somebody who comes in for a building permit to appeal? There is, because we just approved the appeal board, right? So somebody comes in and they want to use the rest of their TDR to build up to 11,000 square feet. Is that something that's appealable if you deny it?
I'm not sure what, I guess presumably they would come in under site plan review or something like that, and that would be denied because they didn't comply with the new floor area limitations, and then that particular application could be appealed to the BOCC, I suppose.
Let's see.
I don't know if it's.
Something like
Something
that, I think.
like that. That's pretty hypothetical. I don't
Trying to-
know.
yeah.
That would be unusual if you're trying to appeal a code.
Yeah.
And I don't know if.
I think to Rye's point, it would be coming into planning first.
Yeah.
They wouldn't be walking in a building
Right.
permit with, so again, we're under the land use code provision of what applies, how is this affected, right? I guess if it was So yes, I think then
There's an
the way
interpretation
Rye
of
described it.
What is
would
the
be-
bottom line? Yes, it's appealable. No, it's not.
If they were, said, I want to run through, take me through whatever process I need to have you deny me that I could build over 9250 with my remaining TDR, then that is appealable to the board.
That would be
Okay.
interesting.
Then I would be okay with D if that's the case. Yes.
I was going to make a motion if you're ready.
Okay,
Yeah.
you're okay with removing D, if that's the case.
Yes, it's a double negative.
Uh,
That's the motion I
Yes,
would make.
exactly.
I would make a motion that we approve it as presented with A, B, and C, as presented, removing D.
I'll second.
Is there further discussion?
And to be continued.
Okay, so all those in favor of Greg's motion, say aye.
Aye.
Aye. All those opposed?
Aye.
Oh, and aye.
I'm opposed.
Okay, so it passes 4-1. All right.
And that was the ordinance of the Board of County Commissioners of Pickens County, Colorado, adopting
Yeah.
text amendments to the 2006 Pickens County Land
Thank
Use
you.
Code
Thank you,
as
thank you.
amended by Greg's motion. There's still 5 different ordinances in front of the board for consideration.
Thank you for that, Ron.
I will make a motion to approve, oh my God, which one are we on?
8.
Number
8.
8.
Brush
You
Creek.
want me to go?
No, yeah, because I've got yesterday. I
Okay,
gave-
ordinance
we're
of
on
the
8.
Board of
Wait, wait.
County Commissioners, Colorado, rezoning all lands within the Brush Creek Master Plan area to the Brush Creek Master Plan Area Overlay Zone District.
Second.
All those in favor?
Aye.
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 Keep rolling, Kelly. You did it
Okay,
last
I'll
time.
move to approve the ordinance of the BOCC rezoning all lands within the Emma Master Plan area to the Emma Master Plan Area Overlay Zone District.
Second.
All those in favor?
Aye.
Aye.
I move to approve an ordinance of the BOCC rezoning all lands within the valleys of Capitol Creek and Lower Snowmass Creek Master Plan Area to the valleys of Capitol Creek and Lower Snowmass Creek Master Plan Area Overlay Zone District.
I'll second that one.
All those in favor?
Aye.
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 You missed Brush Creek. Or I'll move to approve an ordinance of the BOCC rezoning all lands within the unincorporated area of Pickens County within the boundary of the Basalt Urban Growth Boundary to the Basalt Urban Growth Boundary Overlay Zone District or the Bugbo.
Second.
I'll second the motion.
All those in favor?
Aye.
Aye. And
Aye.
finally, I will move to approve the ordinance of the BOCC adopting the Pickens County Final Maximum Floor Area Zoning Overlay.
I'll second that.
Do we have to say that we're omitting D?
That was my question, because if this includes the omission of the language in D, then I'm not supporting it, even though I do support the house size.
My understanding was that the motion that Commissioner Postman made was in regard to item number 7, and that included the addition of A, B, and C, and not including language as proposed in D,
Right.
and that was for number 7. Number
12.
12 does not include that language.
It doesn't?
No.
It's
Okay,
just the
so
overlay.
the motion as made is fine.
So I moved.
Oh, I second it.
Okay,
And
so
I
all
questioned
those
it.
in favor say
Could we
aye.
have just a second discussion?
Sure.
Could we look at I just want to make sure, this is the one that was the big map right at the end of the packet, is that right?
Correct.
Yeah.
So basically,
This
all the land not in the specified caucus areas or the exceptions that is in unincorporated is covered by this final one?
It's the
Yes.
beige slash,
Do you want us to bring that up?
Sure.
it's right here.
Yeah, if you could show the map one more time. So it would be all of that, the brownish color would
Everything
be
that-
what is covered by our final ordinance?
Yes.
Correct.
Jill goes, has a question.
Joe, do you want to ask a question?
Don't you need to include A, B, and C?
That's
Well,
what I
that's what
asked
we're
and we don't.
discussing.
It's
That's
in-
just what we're talking about right now is,
Okay.
thank you. So you're saying that the language as it, for this ordinance, doesn't include A, B, and C, but it will, they will apply nonetheless?
Because of what we included in the code change.
The applicability language lives in the ordinance related to the text amendments. And I guess I'd look to Rye
Okay.
if he thinks.
So we're saying, okay, number 12, we're saying, okay to everything we said in the text amendment. Okay.
Something I didn't think to ask of earlier. Does this undermine rural and remote's 1,000 square foot area cap?
Suzanne specifically drafted it so that the more restrictive floor area standard in rural remote would apply.
Perfect. Thank you.
So then my question is, since I voted no on the code language changes, does that mean I'm a no on this one for the, because you're saying that it applies to that Francie said.
So it would apply across all of the zoning ordinances that are in front of the board. I'm sorry, the text amendment as to how you apply those specific circumstances would apply across the board to all the zoning actions in front of the BOCC. So let's talk about the Brush Creek Overlay Zone District. If you have a vested property right to build above 5750 in the Brush Creek zone overlay, that applicability language in the text amendment ordinance would allow you to, would protect that vested property right to go above 5750. Similarly, if you have an application in the process to build more than 5750 in the Brush Creek zoning overlay, the way the land use code text amendment applies those applicability standards is to say if you're in the pipeline, you would be able to increase floor area above 5750 in reliance on that application that has been deemed complete.
Okay, so I should have voted no on everything.
Well, I don't know what to tell you about that,
Yeah.
but the
Well,
applicability,
I
know, but now if your decision to take that code, the code language out, D, but I don't think that's the case because the caucus districts have their own, and we didn't hear anybody concerned about 57.5 and Maroon Creek or any of those. So I'm okay with where I stand. I will vote no on this one because of its direct impact on the TDR.
I think we've had a motion and a second. Now it's time to
Yeah.
vote. All those in favor of the ordinance of the Board of County Commissioners adopting the Pickens County final maximum floor area zoning overlay, please say aye.
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 And I say nay, and it's
Aye.
not because I don't agree with the house size issue, it's because I don't agree with the elimination of that exemption language.
Okay, so that one passed 4-1.
Thank you, gentlemen and ladies, and everyone who came to visit us today.
Yeah, thank you all so much.
You finally got
Appreciated your input.
cakes.
Okay, it's open discussion.
Is
We're
there
gonna be
anything
out
to
of here
discuss?
in time to finish up our betting activities before APSA starts. Okay, I want to tell you, John, that Osgood Road that I mentioned in Redstone about is a county road. I saw it on Rye's 400-page packet today.
So we're doing some more research actually, and I was hoping to get when we can do this offline, the name of the person I contacted you, so Brian could
Okay.
be in touch.
Okay. But I did see it in his 400-page packet.
Yeah.
But we haven't maintained it for years, have we?
Yeah, and sometimes there's other arrangements that have been made on these roads, so we
Yeah,
wanted to
there was
research it a
another
little
arrangement,
bit
but he
more.
moved
Yeah.
away, so, okay, I'll send you her thing. The ribbon cutting at Response on Friday has not been noticed, and it is this Friday, not December 4th, my bad, at 4 o'clock.
We put a note in yesterday to do that, so it probably just hasn't showed up yet.
Charlotte said there's no way we get it noticed,
I can't
and
be
she
there.
told me to bring it up today. You
I
can't be
already
there?
notified Shannon that I could not be there,
So it's just you and me.
so
Oh, okay.
I will not be there.
We're fine, okay,
Okay.
you're not going, right?
I might, no, I won't go. Well, I'll kind of be in transit, and I probably won't be able to be there by 4.
Okay, so it's a moot point. And
And I just note, if three of you do show up and Ryan check me on this, that we post these to be extra cautious, but if you're incidentally showing up at another event that you're not talking policy issues and such, it's not a violation of open records.
Yeah.
Okay.
Open
I'll be
meetings.
in Glenwood at 3:30, so. I won't
But
be
I
there.
should have Ryan check me on that.
Don't look at each other.
It's, you have to be very, very careful
Mhm.
if the three of you appear at a meeting that could potentially be construed as affecting a policy or legislative determination or a quasi-judicial decision that you make at some later point.
Oh, goodness.
So
We won't
you
have to
want
worry
be
about it on
very
Friday.
careful about that.
Okay.
And to John's point, it's easiest to just notice it if there's a potential that
Right.
that three of you will be there.
So don't go, Patty.
You know what, I'll make an effort not to go.
Okay.
Solved.
Does anybody else have open discussion?
I think Kelly, Francie and I talked about the APCHA issues today, and she explained them to me, and I'm supportive. And I think that's especially the first one. But yeah, I thank you for bringing them to our attention.
Great. I think, the staff is really trying to sort of tighten up how they really assess eligibility for where work is accomplished. The trickiest things for them are self-employed employees, about how good their books are or not are, and we've had compliance cases related to that. So that gets a little.
We certainly have.
Yeah, so that just gets tougher, and they want to be very clear about what constitutes work. So it is a meaningful change.
Especially with all our remote workers these days.
Right.
I'm still getting those things. God.
But I have a question, though. If somebody has a history, like my neighbors don't live next door anymore, but they both worked, they got their paychecks here, they ran consulting businesses from their home, but they traveled a lot. They were traveling, but they managed everything from their house here in Pickens County. And that's where, like I said, their paychecks and all that stuff came to their address here. But they filmed golf championships, so they were all over the world. Would that still eliminate them from housing?
As I understand it, potentially, because if you look at what let's see. So essentially, they're looking for, under all qualification circumstances, that 75% of your income is earned in Pickens County.
So the fact that their consulting business is licensed and registered here in Pickens County?
Well, so it says an employer has office space owned or leased, a commercial lease in Pickens County, and 75% of your income is earned in Pickens County. If you don't have office space leased, that 90% of goods and services must be provided to Pickens County residents, and you have to be able to document. That's if you're located outside of Pickens County. If you have leased commercial space, you need to prove 75%. If you don't, you have to prove 90%.
So my question is then, on top of that, what if somebody is currently living in and purchased it when they were working remotely or they had a business office in their house, affordable housing, and now we change the rule? Does that throw them out, or is there any grandfathering in of people who have already established?
Once you've bought it, it doesn't.
Well, it depends, because
You still have to qualify. in some
so
cases.
it would apply for people renting. For most deed restrictions, they say you have to comply with the current rules. The current rules do not require a requalification once you own. So you have to attest that you meet these rules, but there's not they're not.
There's no enforcement.
Right. Well, there is enforcement, because now they are starting to audit people. So you could get audited, and if you're remote working and you're living in an APSHA housing, you could get kicked out.
And it's purchased.
Yes.
See, I have a problem with that part of it. I'd like to see some kind of grandfathering in of people who are already established in the home they own, and they've been operating a business for years, and then all of a sudden they say, well, God, now I'm only doing 50% of my work here in town, or whatever. Now you're gonna throw me out of the house I own? I'm a little concerned about that.
Yeah. Steve?
We should
food
talk
for
through
thought.
that more.
Did you want to talk on that
Well,
issue?
I have a different subject.
Okay, we'll wait then.
Before we change the subject, were you?
I'm done. I just wanted to see
Yeah.
if there's any opportunity.
That's a hard one. I realize that I wouldn't want to live in APSHA housing, you know, if I could avoid it possibly. I'm sure everybody says that, but it seemed like it's I know people who've lived in it a long time who probably wouldn't qualify under the new rules, and I think that's what Patty's alluding to, so I'm nervous about it.
On both sides of the issue, right?
On both sides of the issue.
Yeah.
On the trades, I'm not sure I understand completely. Owners are not allowed to trade their homes with other homeowners for rental purposes, even if no money changes hands. So say you couldn't leave for a month. It used to be you could leave for 6 months and go somewhere.
You can still do that, and
Right.
there's long-term leave provisions and there's short-term leave provisions. You have to live in your house 9 months out of the year as your residence.
Okay, so I'm not sure I
But
understand the
this,
point of that.
so this line under the short term, the prohibition is like you can't trade your condo for a condo with someone you have no connection to in France and just swap.
Why not?
For any period of time?
Yeah.
Why not?
Well, the way that they're interpreting it is that you're gaining rental, you're essentially gaining income off of it and value off of the property because you're not paying for lodging that you would ordinarily pay for.
So there's no exchange of cash.
Right.
You're exchanging something
You're
of
exchanging
value.
something of value. Now you can they're not.
Clarence Thomas?
I haven't paid that much attention to his ethical considerations, but that is, where this is going. And I was like, well, what if I want to let my friends in Denver come stay, and borrow it while I'm traveling? And they're like, yeah, that's fine.
Yeah, I agree with where you're going on that one. It's the other one I'm not sure I
That
agree
is a
with.
fine line.
It is a fine line,
It's gonna
but
be really hard to
there
enforce.
are sites that allow you to do this. So they're sort of looking to quash people making these exchanges kind of through these online platforms for.
It's kind of like short-term renting
Yeah.
in a way. Your affordable housing unit.
Not exactly, though, but yeah.
Kind of, sort of. Gray area.
Well, I particularly like the first one about aliens, which is
Oh,
a
yeah.
funny word, but.
Yeah, me too.
About what?
Mine got cut off.
Aliens.
Aliens.
E.T. and those guys.
On the plot.
They keep calling somebody.
Steve, what's your point?
Is there something else? Well, yeah, I've got above this, but just this page.
No, that's
Well,
it.
my subject has to do with the legislature's special session
I wasn't done
and
on
how
this.
we want to approach that.
Oh, entirely different subject. Okay.
Before you go.
Entirely
not
different
ready to move
subject.
Okay.
We're not
I'm
ready to
putting you
move
back
on
on
yet.
hold.
Sorry. Okay, in complex priority. I have an issue with in complex priority. Maybe it's built into covenants and you can't change it, but why can in complex bidders qualify for a unit at their category or above? But say they're a retiree and they want to move down, their kids have moved out and they want to downsize, they can't downsize? That's one question. And the other one is.
Yeah, you can go, I think you
Well,
can go down.
right here it says, in complex bidders can qualify for a unit at their category or above. It doesn't say they can go
Oh.
down. That's a problem for me.
You want it to align with the right sizing.
I think they should be able
Yeah.
to right size, isn't that the point?
Yeah, that's
The
a
other
good
part
point.
of it is, in complex bidding, I'm just, from my experience, if it causes a possibility of corrupt practices, black market. And I've experienced it in our affordable housing program. So,
Well, explain that more, because I
well,
can explain why the
if you can say
priority is
it's
there.
not quite the same as if you're in complex, you can choose somebody in complex to buy it. They'd have to bid, but in complex bidders
Right.
get priority. So maybe that solves the problem. Back in the day, there were times when people in complex could,
Oh,
you
let me
could
give you
choose. I
10
could say, I
yeah,
want to sell it to
sure.
Patty instead of you.
Yeah, no,
'cause-
now there's a process.
So the
Yeah.
process will eliminate the ability for cash under the table and things like that.
Right. So you still go. So
Yeah.
there are some neighborhoods that's like North 40 is not required to go through the
Right.
APSHA lottery process, so they can
They
do
do,
exactly
yeah.
what you're talking about. This recognizes the investment that owners have already made in thousands and thousands of dollars to
Common
like,
property.
yeah, and the capital reserves and all of that.
I'm comfortable with that.
But it still it just gives them a higher, like, better
Ranking.
lottery odds than someone who's not in complex.
Okay, so I guess
You
the,
still have to meet all the other criteria for like maximum bedroom size,
All that,
maximum
okay.
occupancy in the bedrooms or minimum occupancy in the bedrooms.
I'd love to see the downsizing included.
Yeah.
And I'd also
I've
like to
added that.
re-explore the trades and, are we clamping down so hard you're gonna have a rebellion?
They're always rebelling.
I mean, some direction on this stuff now is helpful for me in a half hour.
Yeah, well, my neighbors always carried golf clubs. I don't know if you,
You
can consider that a weapon, but.
Pitchforks.
I think there's just been a long-standing policy in the, in this space of this is subsidized with taxpayer dollars. Like, people should not be earning
Trading
additional
and getting
value.
trading it for their chateau in France.
For my trailer at Smuggler, I promise I won't
Believe
do
me,
that.
So,
would take that.
I'm inclined to support it, but unless you all tell me otherwise.
Well, I don't like it because we're already talking about people who qualify for this, so they're not making a lot of money. And how else are they going to go and stay in a condo in
I mean,
France?
remember that 50% of the units are RO. Ownership units are RO.
So that's my feeling, is that we're
That
trying
one-
to support our working class, and this is an impediment to something that I don't think is egregious in any way.
Maybe there should be a number of times or days per year.
Yeah,
or
maybe something like
A
that.
limitation, so it doesn't become an industry. It doesn't become a full-time, it's an occasional opportunity to get away. I'd like to give
Like
people that.
requires permission from
Well, more, how many times per year?
APSHA. I
Your
mean, I don't know.
neighbors will be watching, I assume, but
Yeah.
it seems as if there ought to be a limit, allowed but with limits, so it doesn't seem like it just,
How is that different from allowing them to short-term rent?
well, it is the same sort of thing, so what kind of limit?
I thought
Because
they
right
could-
now, there's a prohibition on
they
short-term
can't do
rentals.
STRs.
So if I wanted to go and to a national park and camp, I didn't need their chateau in France, but, yeah. There we
Well,
go.
but going to a chateau in France is just trading houses. It's not having somebody pay you to stay in your house.
Right,
you
so
can
that
go
would be
camping.
more short-term rental if
Yeah,
I was gonna go
right.
camping and rented my house out.
Right.
I'm still not comfortable with people doing that. I mean, I think the 6 month or 3 months, the provisions that are already allowed for people to go away.
That still stands.
Right.
Yeah,
Right.
I'm-
You
I
still have
sup-
to get 1,500 hours
I
a year,
support
so
that.
how are you gonna travel for?
Right.
Well, the way
Okay.
most people work, you can get 1,500 hours in a couple months around here.
You're okay with it? Okay.
Okay.
I was worried about it, but I think, yeah, they still have the chance to do 9 months a year. They can leave for 3 months if they want to, so, okay.
Okay.
Okay,
Thank
is
you.
that what you
And-
need, Kelly?
Well, I do want to go back to the concerns Patty raised about the eligibility. I mean, it really is the biggest rule
Which one?
change. And let me pull up the red line.
It's the
Related to
second
the
page.
70, you need to generate income.
Oh,
So
right.
like in your neighbors, if their business if they had a W-2 through their business, they would be fine. This is, it just sort of depends on employed, self-employed.
They were self-employed, they were consultants around the world.
I mean,
But
I
they-
don't know.
they
Are
each ran a
Are they
business.
serving the workforce? Are they picking county as workforce?
Well,
I think that's the question
Yeah,
that's trying to
sometimes a year they
answer.
worked X
Right.
Games and they worked World Cup, so there were hours and they probably put in between the two of them, but one's living in Carbondale and one's living in Fruita now, so. And the people who live there now work here, so. But it's just food for thought. Is there a way to grandfather people in who are already in ownership and may have, now are working remotely, and that could be an issue with after COVID.
Well, if they're working remotely, they don't have to live in Aspen. You know what I'm saying? They could live anywhere.
I wonder if your wife lives here with you, or your husband, or
Well, then they should be working and you can get it through them.
if they work 1,500 hours.
I know, it's a lot of hours.
Well, when you're
It's 75%.
Well, the intent of it is to make sure that people living in affordable, housing, which I'll say, you know, that we try to encourage it to be workforce housing. It makes sense to have these regulations, and it's hard to look at them, but
Well, I just don't want to be throwing people out of a home that they bought.
well,
I see if somebody moves in and says, well, I work remotely, but I only work this, or I'm gonna run an office space in my, that's different to me than somebody who's already been living there, who came in under the guidelines, qualified, and then their lives change, and they may have started a business, or COVID forced them, their company to move elsewhere. I mean, there might be some circumstances that are appealable or grandfathered in. Food for thought.
yeah, well, there's the rub.
Goes along with apple cider cake.
Well, we'll bring up that
Yeah.
point.
Yeah, I'll bring it up for sure. I mean, I think staff is bringing this forward because they feel like they're turning people away or people are trying to earn housing that are legitimate, and they are having to defend folks who maybe are less than legitimate as far as being true Pickens County workforce.
And I can see that for people coming in, but maybe not for people who've been in.
So what's the grandfathering? What's the time period to be grandfathered?
I don't know, that's for further discussion if they even want to discuss it. Just an opportunity.
I don't know. I think that's.
Just thought.
I'm going to have a hard time defending remote workforce in owning APSHA housing.
Well, I have a
Know how
problem
to
with that
defend
too,
that.
but okay, I'm saying, I bought in, I qualified under that, I was working here, life changed, COVID hit, my company moved away. Do I have to sell my house when my family's established here? My wife works very part-time. She doesn't do the 1,500 hours, so we have to now sell our house and move where?
Or go back to 1,500 hours.
Then they should appeal.
That's what I'm saying, is they need to have a process that they can do that, or a grandfathering, whatever. I just want people to have an opportunity to stay in the homes that they
I'm sure there are
already
some
purchased.
exceptions that would be okay.
Yeah.
Steve, did you want to contribute
Thanks,
to this
Francie.
conversation, or are we ready to move on? Or both?
You're muted.
Can't hear you.
You're muted, but I don't know what we can do at the state legislature special session.
I would agree with Kelly that, I mean, the purpose of it is that people are holding jobs in Aspen, working for businesses in Aspen, not that they're doing a remote business.
For the
But
benefit of Aspen.
I see Patty's point too, and as long as there's an appeal process for circumstances that we can't exactly foresee,
Okay.
that I'd be all right with that. But we do want to get real warm bodies in there holding real jobs at businesses in Aspen is the whole purpose of the APSHA housing.
I would like to move on if you're okay with that, Kelly.
Yeah, 'cause
We
I
have
need
our
to-
meeting in half an hour.
Yeah, you guys
We
need
a
some,
break.
you need a break.
Yeah. So Steve, what is yours is about the governor's special executive session?
Yeah, so
Legislative
all
session.
the bills had to have been submitted already by legislators to be considered. CCI is having a meeting tomorrow from 2 to 4, a remote meeting, a special meeting of the tax committee, which Kelly's our representative on that, to consider whether CCI is going to support, oppose, or be neutral on various bills. My gut feeling on this whole process, I don't know if the legislature is planning on actually passing legislation in this short special session, but to me, this is an example of really bad governance process, akin to the last week of the legislature when they rammed through stuff that hasn't been vetted properly, we always give a 2 week, 2 weeks between our first and second reading as a minimum for the public to consider it, for us to consider it, more information to come forward or whatever. The legislature likes to ram these things through, which makes me sort of want to oppose anything they're coming up with in the next couple of days, unless they are just moving it forward to January, when it will then be properly vetted and more time to discuss these things. And I wanted to get a feeling from you guys, where should Pickens County come down on these proposed legislative proposals that we're going to be looking at in the next couple of days?
Well, it's hard to know until we
We don't
can
know
see
what we're
them.
looking at.
Yeah, we don't know what they are. I've been trying to look for a list of them and I haven't found one yet, but
Well,
there
Perry
probably
Will
is a
said
list.
that he thought the Democrats might come forward with something pretty interesting, and if they did, he was gonna vote for it. So my guess is that they are gonna be voting, from what he said, but it's just what he said, you know, I don't really know.
I
but-
think I agree that their plan is to have something. They're not gonna wait till the first of the year. Their plan is to enact something overnight like they did last time that failed.
Yeah, like
But
HHB.
maybe it'll be something really good. Maybe they learned their lesson that AHH failed. They need to come up with something substantially different than
I think that is what they're
So,
thinking.
is it just gonna be up to, I mean, Kelly is our official vote on that. I don't know if you can be on that
Yeah, I have it.
call tomorrow.
No, I'm following the conversations and I plan to attend. You know, some of it is they can only do what they're authorized to do at this point, which for me falls in, you know, from what I understand, falls into a couple buckets related to the percentages for the rates, right? So they can adjust those. They can create new rates. They can appropriate money for districts. What else? There's some discussion about touching the income tax rate, which I would really object to. And yeah, but they can't do anything related to like Tabor. Like
Yeah,
they can't
they can't
increase,
backfill with
you know,
Tabor.
yeah. You know, they can take money from next year's Tabor refund to fund the backfill. They can decide proportionately which governments they want to backfill or not. Yeah, that's some of the stuff.
That's one
coming
of the problems with HH was that it was backfilling the school system, but ignoring all the other special districts that were gonna, you know, be really hurt by this.
Yeah.
Well, I would trust Kelly's ability to make the right decision for us.
Thanks. I mean, I continue to sort of argue like they don't even have a clear picture of what property tax implications at the local level are right now. You know, like there's just some big hype about like everyone's property values went up. Well, property value is not property tax. Like there's
God, you
they
know how
have
many times I've said that.
you know,
Oh
they
my
have such a
God.
divorced
Yeah.
understanding of like what we're trying to do on the ground, what the reality of people's tax bills are going to be. You know, so sort of some of my I always lead with that. You know,
Do you guys understand what we're talking about?
like why do you feel the need to like wade into this space anyway
In a
if
hurry.
if you can't even clearly articulate
Yeah.
like what the problem is? So
I'd love to adjourn.
Motion to adjourn.
Wait, I have one more quick thing. I brought it up with Francie briefly and John at more intensity. I'm gonna be looking at putting on an agenda discussion with the board about our employees' paid time off. And how people who have accrued because of staffing issues or whatever, and how we might want to reevaluate the policy that we have. But I think we need to have that discussion as a way to retain our employees and compensate them for the value of the work that they do for us. So,
Okay,
thank you.
thank you.
all righty. Do we have a second?
I think I seconded. Second?
I'll
Yeah.
second.
I don't know.
I'll second too.
All those in favor of adjourning, please say aye.
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 Thanks, guys.
Thank
Thanks,
you.
Ryan.
Okay,
Nay.
and Dora, you're
Nay.
off.